live together tomorrow.
With kind permission. Not the MFS matter, the second list, today some matters are listed on the delay. Some submission, since the appeals have dismissed on the ground of delay and consequently appeals also dismissed. My one submission, since some clarification regarding that, this is not decided on the ground of merit. Hence, this cannot be considered as a determination of market value. Some observation about that, my lord. Otherwise, my lord, on technical
limitation apply ಮಾಡಿ.
Please, on because my lord, it not necessary in respect of the High Court is concerned, my lord, but the trial court, my lord, or the reference court. That
ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಇದ್ರಾಗ ಯಾವ ಆರ್ಗ್ಯೂ ಮಾಡ್ರಿ ಅದ್ರಾಗ ಹೇಳ್ಬಿಡ್ತೀವಿ ನಾವು.
ಅಲ್ಲ since my lord, that's observation in those cases also, my lord. Otherwise, my lord, it will affect the entire
Other
instead
cases.
of other cases also, my lord. The reference code
sentence and then sentence but learned AAG Mr. Gangadhar is right in submitting that by this judgment we should not be construed to have said, construed to have affirmed the determination of compensation by the reference court. Since we have rejected the appeal on the ground of limitation without examining the matter on intrinsic merits.
Please, one more submission.
You are very wise advocate. This is advocacy actually.
One more submission. Well, these are the around about 500 appeals. The state is not in a position to prepare SLP against all these appeals. And moreover, the SLP is already pending before Honorable Supreme Court. The only one observation, revival of these appeals, in the case if the global mill decided in favor of
make
state.
it clear that this judgment shall be subject to the result of pending SLP number so and so. So first off, this clarification we are issuing because we have heard and decided this appeal during the pendency of the SLP against the order of review in global.
Please. Main matter as well as the SLP has filed, main matter as well as against the review. Against both order we filed a review.
Against main matter you have withdrawn.
I'll withdrawn. In that order,
You have challenged that also.
No, please. The SLP is
Review and the main matter as well. ಆ ರೀತಿ ಒಂದು ಸ್ಟ್ರಕ್ಚರ್ ಮಾಡಿ ಲಾಸ್ಟ್ ಇದನ್ನ ವೆಬ್ಬೋಸ್ಟ್ ಆಗ್ಲಿದ್ರೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
For these circumstances, my lord, the article 140 power of article 142 available for Supreme Court should also available for the High Court. So these are the cases. The reason is that, my lord, these are the cases where this honorable court can also exercise the power to condone the delay, at least few cases. Otherwise, my lord, the act itself says, my lord, is.
But earlier view was no law will control 142.
But now, my lord, now Supreme Court
change.
Parallel jurisdiction, that is almost the exercise of the power of Supreme Court. Parallelly to the 142 is a parallel jurisdiction.
In fact, Nariman
Please.
has said the very purpose of 142 is to render justice even outside law.
Please.
Therefore, he has criticized the two judgments in his court signed their judgments. In his the state of the nation. State of the nation. The ಎರಡನೇ book. He has criticized. Just hange ನೋಡಿ ಅದೊಂದು xerox copy ಕೊಡಿ ನಂಗೆ.
Please. Yes.
I want to just
Please.
refresh my memory.
In list number 2,
certain matters are under old act. By oversight, they have been.
ಅವ್ನು ತೆಗೆದುಕೊಂಡು.
Please. It is in turn beneficial for the all of our colleagues, my lord, but burden for my lordship, my lord, because we have to sign all those orders.
ನಮ್ಗೆಲ್ಲ ನಿಮ್ನೆಲ್ಲ ಹಿಯರ್ ಮಾಡಿದಾಗ ಖುಷಿ ಆಗ್ತದೆ. We learn so much and the Dharwad bar has upgraded itself like this is unprecedented upgradation.
For 8 weeks, my lord, refresher course also.
For us also.
My request to delink the matters under the old act which have
ಅದು
been.
old act ಯಾವ್ದಾದ್ರು ಹೇಳ್ಬಿಡು.
Serial number 26 and 27, madam.
Number per mark
Please,
ಮಾಡ್ಸಿ.
please.
Mark ಮಾಡ್ಸಿ.
Please.
Serial, one submission. Serial number 82, man.
82.
82. In this case, there is a delay. What has happened, my lords? In this judgment, reference court has awarded, my lords, compensation for trees also.
Correct.
Whereas in the simultaneously, claimants have approached SLO once again, taking order of mandamus from this court, and additional award has been passed. My lords, and I have challenged that award in the writ petition. This may be taken up on Monday. My lords, I will
Separate ಮಾಡ್ಬಿಡಿ.
20.
ಯಾಕಂದ್ರೆ ಅದು ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಏನಿದೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
Please. 82. Please.
ಅದರ್ 10-12 ಮ್ಯಾಟರ್ಸ್ ಇತ್ತು ಗಂಗಾಧರ್, ಅವುಗಳನ್ನ ನಾವು ಸಪರೇಟ್ ಮಾಡಿಬಿಟ್ಟಿವಿ. ಅದರಲ್ಲಿ ನಾವು ಸಪರೇಟ್ ಮಾಡಿದ್ದೇವೆ ಯಾಕಂದ್ರೆ ಬೇರೆ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ. ಒಂದು ಫೈನಲ್ ಆಸ್ಪೆಕ್ಟ್ ಅಂದ್ರೆ ದೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಅಂಡರ್ ದಿ ಓಲ್ಡ್ ಆಕ್ಟ್ 1894 ಆಕ್ಟ್.
Please.
But award is passed under the new act.
That is global mill also similar situation.
Correct.
Please.
Global cover ಮಾಡಿಬಿಡುತ್ತೆ.
Like global mill also similar situation. The initiation was under the old act, but the award was under the new act. That is why Supreme Court, in the Supreme Court, state has withdrawn. Since it is a initiation under the old act, so appeal under 75, 74 is not maintainable. So that was expressly rejected under the, by the His Lordship Justice Virap.
Europe review petition.
Yes.
ಹಂಗಾಗಿ ಅವು ಕವರ್ ಆಗಿಬಿಡುತ್ತೆ. ಅವು ಕವರ್ ಬಟ್ ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ recast paragraph relating to right of appeal accruing when the original proceedings are instituted, although the right becomes exercisable after the culmination of said proceedings. ಇದನ್ನ line because of global.
But with kind leave, serial number 7 and
7 to 15.
15
7 to 15 first list
and 20 and
19,
onward.
20.
second list.
Second list.
Second list.
Respondent, my lord. My lord, in this case, there is a already delay, my lord. It is a more than 120 days.
Please.
Computation of limitation under section 74 is not is the subject matter that is to be decided by this honorable court. ASG is going to argue in the matter in a similar circumstances on day before yesterday, my lord.
One branch lordship has delinked.
Dealing with the matter.
ಅದರಲ್ಲಿ ಬರ್ತಾ ಇದೆ ಡಿಲಿಂಕ್ ಮಾಡಿದ್ರಲ್ಲ 7 to 15
7 to 15, 19, 20, and I have given the numbers.
ಬಟ್ ಎಲ್ಲೆಲ್ಲಿ ನಾವು ಡಿಸೈಡ್ ಮಾಡಿಲ್ಲ ನಾವು ವಿ ಆರ್ ನಾಟ್ ಆನ್ ಡಿಸ್ಪೋಸಲ್ ಮೆನಿಯಾ. ಎಲ್ಲೆಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಒಪ್ಕೊಳ್ತೀವಿ, ಎಲ್ಲೆಲ್ಲಿ ನಾವು ಸುಮ್ಮನೆ ಏನೋ ಮಾಡ್ಕೊಂಡು ನಂಬರ್ ಇನ್ಕ್ರೀಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಗೊತ್ತಿಲ್ಲ. ಪ್ಲೀಸ್ ಹಂಗಾಗಿ ಮ್ಯಾಟ್ರಸ್ ಎಲ್ಲೆಲ್ಲಿ ಮಾಡ್ಕೋಬೇಕು ಮಾಡ್ಕೋಬೇಕು. 14 after 60 14 is 16 plus 60 plus this. Okay. I'm sorry. Okay. 7 to 15.
Yes, sir.
7 to 15, 19, 20, and others. These are the batch connected matters.
Last
Delink. Delink ಆಗಿದೆ.
ಅವನ್ನೆಲ್ಲ ಡಿಲಿಂಕ್ ಮಾಡ್ಬೇಕು, ಅದ್ರ ಜೊತೆ ಸಪರೇಟ್ ಹಿಯರಿಂಗ್ ಆಗ್ಬೇಕಾಗತ್ತೆ.
ಇದ್ರ ಜೊತೆ
ಯಾಕಂದ್ರೆ ಆಸ್ಪೆಕ್ಟ್ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. In ಉಳಿದಂತಾವು in terms of that we are disposing of those. Thank you, Mr. Gangadhar.
Please, Public. Great.
This one, orders matter 1.
Bas.
That's in the second list. That's I appear for some of the cases. So they have said that.
ಕೂತ್ಕೊಳ್ಳಿ, ಯಾಕೆ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಯಾಕೆ ನಿಂತ್ಕೊಂಡ್ರೆ? ಕೂತ್ಕೊಳ್ಳಿ, ಎಲ್ಲರೂ ಕೂತ್ಕೊಳ್ಳಿ, ಚೇರ್ಸ್ ಇದಾವಲ್ಲ, ಕೂತ್ಕೊಳ್ಳಿ.
In serial number 54 and 57, these are the appeal filed by the claimant. Very much, there is a they says.
ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್?
54 and 57.
54, 57. List
List 2, my lords.
ಹಾ
ಅಲ್ಲಿ ಡಿಲೇ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಮೆಲಟ್ಸ್. ಇನ್ ಫ್ಯಾಕ್ಟ್ ಮೆಲಟ್ಸ್ ಐ ವಿಲ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ದ ಡಿಲೇ. ಮೆಲಟ್ಸ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಮೆಲಟ್ಸ್, ಇಟ್ ಈಸ್ ವಿದಿನ್ ದಿ ಮೆಲಟ್ಸ್ ಅಪೀಲ್.
ತೋರಿಸ್ಬಿಡಿ, ರೀಚ್ ಆದಾಗ ಹೇಳ್ಬಿಡಿ,
ಪ್ಲೀಸ್
ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ. ಹಾ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಹಾ
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
ಅಂದ್ರೆ ಸೆಕ್ಷನ್ 14 ಅಂದ್ರೆ ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಆಫ್ ಟೈಮ್ ಇದನ್ನೆಲ್ಲ ಲೆಕ್ಕ ಮಾಡಿದ್ರೆ ವಿದಿನ್ ಟೈಮ್ ಇದೆ ಅಂತ.
ವಿದಿನ್ ಟೈಮ್ ಅಪೀಲ್ ಇಸ್ ಮೆಲಟ್ಸ್ ವಿದಿನ್ ಟೈಮ್.
ಹೇಳ್ಬೇಕು.
Number 1,
The period of the petition.
ಹಾ ಕರೀರಿ. ಹಾ
This is the, Lord, habeas corpus, same matter, Lord.
ಹಾ
Lord, after the last time, Lord, when the matter was listed, Lord, the investigation has conducted, two different way, Lord. One is,
ಡೀಟೇಲ್ ಕೊಡಬೇಡಿ,
Sorry.
because many will be seeing that may derail the investigation. ಹಾ
Lord, we conducted the inquiry. Lord, we have inquired, Lord, all the connected persons who are involved in this person, Lord. We have also called for the main suspected persons, Lord, who was on that time, Lord. He has inquired. Lord, all other 4 persons, including the officers of the company, whom they have except, Lord, agreed, Lord, whatever the last time which you mentioned, that, Lord, there is something, Lord, they amount was required, they have agreed this time. But, Lord, they have some hesitated to give the, but the statement which we have taken, in the statement they have given it, that was recorded in the, and also videograph has done this time, Lord. The statement was videographed, everything is done. And Lord, we have visited the, Lord, Telangana also.
ಈಗ ಏನಾಗಿದೆ ಹೇಳಿ, ಎಂಡ್
Lord,
ಪ್ರಾಡಕ್ಟ್ ಹೇಳಿ.
The end product is, Lord,
He continues to be detained.
yes, Lord.
ಮತ್ತೆ ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Lord, we need some more time, Lord, because the reason, Lord, what happening is, Lord, whenever, Lord, we started investigating, Lord, who is involved in this group, that advocate immediately calls us. Immediately.
ಎಲ್ಲದಕ್ಕೂ ಅವರೇ ನಾನೇ ಬರ್ತೀನಿ, ನಾನೇ ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
Immediately, my Lord, who are involved in any other persons, immediately, my Lord, within the span of 10-15 minutes, my Lord, she called back. Nimge yake, I will come, whatever you want, you just asked me. Don't harass.
ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ನೋಡಿ.
ಅದನ್ನ ಹೇಳಿದೆ, my Lord.
ನಿಮ್ಗೆ
ಸ್ವಲ್ಪ
ಬಿಟ್ಟಿದ್ದು.
ಅದು
ನಾವೇನ್ ಹೇಳಲ್ಲ.
ಅವರು ಸ್ವಲ್ಪ ಲಾಯರ್ ಇದ್ದದಕ್ಕೆ ಬದಕ್ಕೆ ಇವರು SP ಅವ್ರ ಜೊತೆಗೆ ಮಾಡಿ ನಾವು ಟೇಕ್
ಮಾಡ್ಬೇಕು.
ಪ್ಲೀಸ್ ಡೆಫಿನೆಟ್ಲಿ
ಲಾಯರು, ಜಡ್ಜು,
ಅದನ್ನ it will not make any difference.
we are all under law. We are all under law. ಹಂಗಾಗಿ ಏನ್ ಮಾಡ್ಬೇಕು?
Please.
ಲಾಯರ್ ಇರಲಿ, ಜಡ್ಜ್ ಇರಲಿ,
It will not,
ಮಾಡಿದ್ರೆ ಏನಾಗತ್ತೆ.
some more time, Lord, they,
some more time ಬೇಕು ಅಂತ ಇದ್ದಾರೆ.
Please, may I make one submission? Whatever my friend saying, Lord, but now the police have made us as a prosecution witness. Not all, not advocate and the one Reddy come to their given a statement and ಯಾವಾಗ ಬಂದ್ರು ನೀವು ಕೋರ್ಟಿಗೆ ಹಾಜರಾಗಬೇಕು, prosecution ಪರವಾಗಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಬೇಕು. Therefore, we are cooperating. What advocate is coming, Lord, he know no Hindi, but others are not, persons are don't know the Hindi. Therefore, to communicate between the police and others, he wants to come only to assist the prosecution.
Anyway, you are not holding a brief for the
Brief for
advocate
lawyers.
at all.
Yes, yes.
You are holding brief for the detainee side.
Please.
Therefore, you need not argue at all.
Please.
the amount transaction, some of the amount
ಏನ್
is
ನೋಡಿ,
proved.
ನಾವು ಸಿಂಪಲ್ ಆಗಿ ಹೇಳ್ತಾ ಇದೀವಿ. ನ್ಯಾಯಾಧೀಶರು, ವಕೀಲರು, ಅಬೌವ್ ಲಾ ಇದಾರ,
No.
ಬಿಡಿ ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ.
Please.
ಅಷ್ಟೇ ಉತ್ತರ. ಇದರಲ್ಲೆಲ್ಲ ಬಂತು. ಆನ್ ರಿಕ್ವೆಸ್ಟ್, ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ಥರ್ಡ್ ವೀಕ್ ಆಫ್ ಅಕ್ಟೋಬರ್,
Please.
ಅಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ದಸರಾ ವೆಕೇಶನ್. ನೋಡ್ಕೊಳ್ಳಿ,
Please.
ಏನ್ ಮಾಡ್ಬೇಕು ಅದು ಮಾಡ್ಬೇಕು.
Please.
ಓಕೆ.
Case of amputation.
ಎಸ್.
Petitioner, apparent age is, my Lord, 17, my Lord. Left hand is amputated. Tribunal has ought to consider the 6,000 rupees salary, my Lord. They have taken 4,000 rupees.
ಎಸ್ ರಣಿ, ಏನ್ ಮಾಡ್ಬೇಕು?
ಇಲ್ಲ, ಅನೌನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಇಲ್ಲ ಅಂತಲ್ಲ.
ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
ಇಟ್ಸ್ ಎ ಕೇಸ್ ಫಾರ್ ಅನೌನ್ಸ್ಮೆಂಟ್.
ಕೇಸ್ ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
Salary is taken as 4,000, my lord, as per
ಏನ್
chart.
ಮಾಡ್ಬೇಕು ಹೇಳಿ?
6,000.
You have a very
Please,
fair
please.
friend. He is a good friend of the court also, that's another thing. Yes,
Only thing is, petitioner himself has stated that his income is 5,000. So that 5,000 has to be maintained. Court has taken 4,000.
As per chart, 6,000.
ಅಲ್ಲ, petitioner ನಾವು
ಅವ್ರು
ಹೇಳಿದ್ರೆ
ಹೇಳಿ.
ನನ್ನ income 5,000 ಅಂತ ಹೇಳಿದ್ದಾನೆ.
our duty is to award just compensation.
Correct.
Therefore, what he claims is not
ಅಲ್ಲ,
deceiving for
what
us.
he claims, they admitted in salary or income of his own, it is 5,000. That's what he has claimed.
Chart value minimum ಇಟ್ಟಿರ್ತಾರೆ.
ಅಲ್ಲ, ಯಾವಾಗ ಅದು ಚಾರ್ಟ್ ವ್ಯಾಲ್ಯೂ ಯಾವಾಗ ಹೇಳ್ತಾರೆ?
Which
To my,
prospect is considered as 30,000, 30%, my lord. They have to announce 40%. 30% grant.
30%.
And disability is considered as 50%, my lord. It should be 100% functional disability.
ಯಾಕೆ?
And the amputation case ಅಲ್ಲಿ 100% ಹಿಡಿತಾರೆ.
Amputation is 100%.
100% judgment ಇದೆ.
90 ತಗೋತಾರೆ, 90 ತಗೊಂಡು ಬೇಕಾದಷ್ಟು ಕೇಸ್ನಲ್ಲಿ. 90.
ಆಯ್ತು.
Please.
ಬಟ್ ಅಲ್ಲಿ ಒಂದು ಇದಕ್ಕೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೇನೆ.
100 ಹಿಡಿದ್ರೆ ಅದರ್ ಹೆಡ್ಸ್ ಅಲ್ಲಿ ಕಮ್ಮಿ ಮಾಡ್ಬೇಕಂತ ಇದೆ.
ಕೊಟ್ಟಾರೆ ಸರ್.
Para 9. Paragraph 9. Under the head of pain and suffering, the High Court has awarded a sum of rupees 40,000. The appellant wants this sum to be raised to rupees 6 lakhs. Relying on a judgment of this court in the case of Mallikarjun versus Divisional Manager National Insurance Company Limited and another. In the case of Kajal, where the victim was a young girl of 12 years, having suffered 100% disability, the amount awarded was rupees 15 lakhs under the head of pain and suffering and loss of amenities. But this judgment quantified such award with the caveat that the sum was awarded in the peculiar facts and circumstances of the case. In the case of Rajkumar versus Ajay Kumar, it has been observed that when compensation is awarded by treating loss of future earning capacity to be 100% or even anything more than 50%, the need to award compensation separately under the head of loss of amenities or loss of expectation of life may disappear. So only nominal amount is to be granted. That's what the Supreme Court has said. I'm not against that it should not be granted. When 100% is considered, then the nominal amount is to
Other
be
things
granted.
will go.
Other rest, that's all. ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಹೇಳಿದ್ರು.
ನಾಮಿನಲ್ ಹಿಡಿದಿದ್ದಾರೆ.
40% ಆಗುತ್ತೆ ಇಲ್ಲ. ಹೌದು ಹೌದು ಹೌದು.
16,32,000 16,32,900 16,32,900 ಆಗುತ್ತೆ.
ಅಲ್ಲ, 90%.
ಮೆಮೋ ಆಫ್
90% ಹಿಡಿದ್ರೆ
90 ಹಿಡ್ಕೊಂಡ್ರೆ
ಹೌದು.
ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡಿ. ಚೀಟಿ ಬರುತ್ತೆ ಸಣ್ಣ ಬರ್ರಿ.
ಆಯ್ತು. ಪ್ಲೀಸ್.
ಪ್ಲಸ್ 2,400 ಅಂದ್ರೆ 2,400 18 into 12
ಇಂಟು ನೆಟ್.
ಪ್ಲೀಸ್.
ಅಲ್ಲ, ಅದೊಂದು ಜಜ್ಮೆಂಟ್ ಒಂದು ರೆಫರ್ ಮಾಡಿ.
ಒಂದು 50,000 ಎಕ್ಸ್ಟ್ರಾ ಇದೆ.
ಪ್ಲೀಸ್.
ಅಷ್ಟೇ ಆಗುತ್ತೆ.
3 Lakshmikant Reddy.
My lords, in both the cases, the liability is fixed on the owner, my lords, on the ground that driver did not have the license, my lords.
ನಾಗರಾಜ,
Insurance company has,
So owner come driver ಮೇಲೆ
ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಕವರ್ ಆಗಲ್ಲ,
ಹಂಗಲ್ಲ ಪಿ ಎ ಕವರಿ ಅಂದ್ರ ಪೇ ಅಂಡ್ ರಿಕವರಿ
ಮಾಡ್ಕೋಬೋದು.
ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ ಈಸ್ ದ ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಮೇಲೆ ಅವನೇ ಇರೋದ್ರಿಂದ pay
my
and
lord, that
recovery.
is, claimant is the third person.
ಹಂಗಲ್ಲ ಸರ್, ಅದು ದಿ ಕ್ಲೇಮೆಂಟ್ಸ್ ಆರ್ ದಿ ಥರ್ಡ್ ಪಾರ್ಟಿ, ನಾಟ್ ದಿ ದಿಸ್ ಒನ್. ದಿ
ಓನರ್ ಕಮ್ ಡ್ರೈವರ್
ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಯಾರ ವಿರುದ್ಧ ನಾವು ಇದನ್ನ ಕ್ಲೇಮ್ ಮಾಡ್ಕೋಬೇಕು, ಅವನೇ.
ಅಪ್ಲಿಕೇಶನ್
ಪ್ಲೀಸ್.
Venkatesh Khan, please.
It is covered by this one.
ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್.
Covered by judgment, my lords, but only contention in similar case, my lord, Hubli Keshwapura, the trial court has given 75,000, my lords. That's only contention. But ಉಳಿದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. In the recent case, my lord, there is 2021, LIC number 102/14. So trial court assess regarding the fertility of the soil of the and accessibility of the land granted 75,000. ಅದು 2,50,000 ಇದೆ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ರೆಡ್ಯೂಸ್. ನಮ್ದು 1 ಗುಂಟೆಗೆ 3,23,000 ಮಾಡಿದ್ದಾರೆ.
ಎರಡು ಕೇಸ್ ಒಳಗೆ
ಅಲ್ಲ ಕವರ್ಡ್ ಇದೆ.
ಈ ಪ್ರಕಾರ ಏನ್ ಡಿಟರ್ಮಿನ್ ಆಗಿದೆ ಅದೇ ಸಿಗ್ತದೆ.
Connected with, my lord, 14 and 39 ಅಲ್ಲ
serial number
set of same LIC. 14 and
for
39.
enhancement, wherein 1,25,000 has been awarded, it has to be enhanced to
ಎಲ್ಲ
2,50,000.
ಸೇಮ್ ಇದೆ ಅದು.
Serial number 14 and 39.
39.
39.
I undertake to file wakalat on behalf of the respondents.
Undertakes to appear for the respondent. He is permitted to file wakalat within a period of 4 weeks.
3 and 4 I accept notice.
The CGP accepts notice for respondent for 3 and 14 and 39. These appeals are filed challenging the first paragraph. The council appearing for the defense as well as the Indian government.
Union of India, represented by SWR, Southwestern Railways.
Statement of this court in bench dated 10/10/2023 passed in MFA 102332 of 2020 and of the said submission. These appeals are allowed in part the impugned judgment and award of the reference court dated so and so.
Madam, bad illa.
Case number so and so by the so and so court is modified. The slash claim
Bad.
are entitled
Water bad.
50,000 work from as contempt. Institute the other degree.
Please.
Court fees,
Court fees have been paid.
We have paid, sir. ನಾನು ಅದರಲ್ಲಿ ನಂದ್ರಲ್ಲಿ paid ಮಾಡಿದ್ದೀನಿ.
Registry to refund the necessary. Bill is disposed of with cost number. Cost last year. The registry to.
We have also paid the court fee in first appeal, in seal number 4.
Is it paying eligible?
Admissible.
Admissible. To the respective parties. Out on the accordance. In accordance.
Please.
5 BP Bhatti.
There is awaiting of report, Your Honor.
One
The
submission.
warrant has been issued.
Warrant is not executed.
Your Lordship, one submission, my lords. On behalf of accused number 2 and 3, my lords, have been instructed to appear, my lords, on this.
No, but warrant has been issued, na?
A bailable warrant was issued, my lords, for a sum of 25,000 each. Lords,
Whether
since
warrant is executed.
my lords,
Why warrant is not executed? When warrant is issued, why you are in hand in glove with the officers? Why warrant is not executed? Telangana state. Anyway, our police have to do it, na? Huh?
yes, Your Lordships, accused number 2 and 3 as well. But lords, last night I was instructed. I have written confirmation for lords undertaking on behalf of them.
Shri, so and so appears for respond person. So first, the coordinate HCGP is requested ascertain why the bailable warrant issued by this court has not been executed, and upon whom the lapse lies, so that this court can take action against the guilty officials. Call this matter. Yavaga complaints.
On Monday, my lordship.
Monday? Time ಮಾಡ್ಬೇಕು.
I'll secure the records and I'll seek instructions as well.
Please. Application ಬರ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Application. Please.
6.
Date ಕೊಡ್ಬೇಕು. Contempt ನಲ್ಲೆಲ್ಲ date ಕೊಡ್ಬೇಕು. They are all criminal matters.
Matters pertaining to the grant of land to the ex-serviceman.
Your Lordship may take 6.7, my lord. There we have placed on record some material to show that some time is required, my lord. We have filed an affidavit of appellant number 4.
Time for what?
Because a letter is a tamge note.
We had asked to give full particulars.
Please, my lord, for that, my lord, there is a letter of the principal secretary addressed to all the regional commissioners, 4 regional commissioners seeking information. In turn, my lord, they require some time to take from each taluka level. That's why, my lord, they are seeking 4 weeks' time to file the consolidated, my lord, the statement before this honorable court. My lord, your lordship may look to my.
At the request of learned additional advocate general, Mr. Reddy, all this matter in on date adar kodi 18/20. 21st.
Please, highly obliged.
Finally. Okay.
Please.
Guru.
Lords,
Arising out of the same
applied,
judgment.
Lords, the application that has been filed by the deputy, before the deputy commissioner for conversion of the land, my lords, from agricultural purpose to non-agricultural purpose. My lords, that was rejected by the deputy commissioners, my lords, without assigning any reasons, by merely stating in one word.
Order ಹೇಳಿ ಮುಂದೇನಾಯ್ತು? Order ನಲ್ಲಿ ಏನಿದೆ?
Order, my lords, there is a direction for me to issue the challenge, my lords, for conversion. That order is under challenge. The 2, my lords, when I have filed the contempt petition, when the contempt notice stands served upon them, they come up with a writ appeal to defeat the contempt.
Serial number ಏನಿದೆ?
7.
Appeal ಇದೆಯೇನೋ?
Yes, ಹೌದು. We have filed appeal.
The appeal, my lords, after service of notice of contempt notice.
Right of appeal ನೋಡ.
Lord, our
delay ಎಷ್ಟಿದೆ?
delay 156 days.
Delay ಕಂಡೋನ್ ಮಾಡೋಣ. ಏನಿದೆ? ಮೆರಿಟ್ ಮೇಲೆ ಏನಿದೆ?
Please, my lord, one respectful submission to the lordship is that
Appeal is filed after brooking delay of so many days. First, an application supported by an affidavit seeks its condonation. First off, plausible explanation having been shown, delay is condoned.
Please.
Appeal ನಲ್ಲಿ merit ಮೇಲೆ ಏನಿದೆ?
Yes, my lord, my respectful submission to the lordship is that 2 contentions before the lordship. One contention is with regarding to making the Urban Development Authority as a party to the writ petition. The writ petition was filed challenging the order passed by the deputy commissioner with regarding to rejection of his application for conversion of usage of land for agriculture to non-agricultural land.
Correct.
Since, my lord, my second respectful submission is that, my lord, since that a property which they are seeking for conversion, it comes under the green belt area of the Urban Development Authority. And invoking the provisions of section 14 capital A of the Karnataka Town and Planning Authority, it is the competent authority is the Urban Development Authority who has to consider his application and to submit a report to the deputy commissioner, and thereafter the deputy commissioner has to adjudicate with regarding to conversion or not. With regarding to that, my lord, may I pass on the judgment of the division bench of this honorable court?
ಅದು ಗುರುಗೂ ಒಂದು ಕಾಪಿ
ಕೊಡ್ತೇನೆ. In that, my lord, para.
This is judgment which Ram.
Yes, my lord, yes. Wherein, my lord, it was decided with regarding to Bangalore VDA.
Held.
Yes, that DC is not a competent. Yes. Para 9, my lord.
Para
9.
Does it hold water even today?
Yes, ma'am.
This judgment is not loosened.
No.
ಹೌದಾ?
Para 9, my lord. Therefore, the question which arises for consideration whether the special deputy commissioner had any power at all to accord permission under section 95 of the Karnataka Land Revenue Act. The chapter 3, section 9 to 13 of the Planning Act provides for the preparation and
ಅವ್ರು ಹೇಳ್ದಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. DC ಬರೋದಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ, Milords, I have made an application, Milords, for conversion of the land from agricultural purpose to non-agricultural purpose.
Correct.
ಹೌದು.
But what Justice Rama Joyce says is, the bench headed by Mr. Rama Joyce, this great judge, is 3-4 books are wonderful. About 6 books he has written. One is Services under the State in Service Law. One of the finest books published by Indian Law Institute. Then Administrative Tribunals Act. He has written a commentary. Then he is the Legal and Constitutional History of India.
Legal and Constitutional History.
Wonderful book it is. Several books he has written. See, and that author of this judgment, he says, if it falls within the ODP,
Yes.
CDP, whichever, then it goes out of the jurisdiction of Deputy Commissioner. Para 9 ನೋಡಿ. ಇನ್ನು ನೋಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡು ಒಂದ್ಸರಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೋಣ, ಈಗ ಅಲೋ ಮಾಡೋ ಬದ್ಲಿ ಒಂದೇ ಸರಿಗೆ ಒಂದ್ಸರಿ ಜಸ್ಟ್ ನೋಡ್ಕೊಂಡ್.
I'll just
Call this matter after vacation.
please.
Let the contempt proceedings shall be dropped and the lordship shall stay the
Contempt
order.
drop ಮಾಡ್ಬಿಡಿ. Let it be together, Milords. I will
ಹೆಂಗ್ ಇಲ್ಲಿಗೆ
address-
ಬರ್ತದೆ? ಇದಾದ್ಮೇಲೆ ರಿವ್ಯೂ ಮಾಡ್ಕೊಂಡ್ಬಿಡು.
I will address
Revive
Milords on
ಮಾಡ್ಕೊ.
this point.
ಅಲ್ಲ,
Because I
ರಿವೈವ್
have-
ಮಾಡ್ಕೋ.
Please.
ಇದಾದ್ಮೇಲೆ you can have the revival by moving a memo. We'll say that.
Instead of revival, Milords, let it be there, Milords. I'll
We have
justify,
taken-
Milords. There are series of judgments, Milords, which says, Milords, even after the conversion of the land from agricultural purpose to non-agricultural purpose, I cannot use that land, Milords, as I wish. I will have to go and approach the planning authority.
ಅದು ಕರೆಕ್ಟ್.
It is-
ಅದು
it is
ಅಪೀಲ್
that-
ಮೇಲೆ ಆಯ್ತು. ಇದಕ್ಕೇನು ಅಂತ ಕಂಟೆಂಪ್ಟ್ಗೆ.
ಅಲ್ಲ,
ಅಪೀಲ್ ಇಸ್ ಪೆಂಡಿಂಗ್.
Milords, absolute, if my lords could kindly see the order that has been passed by the deputy commissioner, he does not even, Milords, mention as to why is he rejecting
No,
my
if he
application.
has no jurisdiction,
No, he has
what he
jurisdiction.
says is irrelevant.
No, Milords. He has jurisdiction. The conversion order has to be provided by the deputy commissioner alone.
ಆಯ್ತು, all right, after vacation. ಮುಂದುವರಿಯೋದು ಮಾಡಿ.
Great.
Lord, I am seeking for stay of the learned.
ಅಲ್ಲಿ the contempt proceedings shall not be precipitated since appeal is pending. Okay.
Yes. Both the appeals.
First off, this we are saying in view of division bench judgment in Special Deputy Commissioner versus Narayanappa, ILR
2008. 1998, madam. 1988.
98
ಹೌದು.
ಇದ್ರಾ?
ಹೌದು, 1988.
ಎಲ್ಲಿದೆ?
ಹೌದು,
1998
KIR
He
1390.
after we joined them.
My lord,
He
this,
retired as
Allah,
Chief
this
Justice
was,
of Punjab, Haryana.
Allah, ILR 1988, KIR
88.
88.
Yes.
88.
ILR 1988, Karnataka,
ILR 1988, Karnataka 1398.
1398.
Yes.
Okay.
Both the appeals. ಎರಡು appeal ಇದೆ.
Yes.
Great.
For the appellant in this matter, your lordship.
Yes, Mr. Baggi.
Appellant had challenged the order of the 25/6/2024, that is an interim order passed by the in writ petition number 1000-758/2023. In that, the herein respondent are not served the copy to me because I am the contested respondent in the writ petition, because for number 7 has been granted.
You are a contesting respondent.
Please, your lordship. Since occupancy rights has been granted in my favor, nor they have served the copy to me, nor they given the opportunity to me.
That interim order.
Yes,
You seek vacating of the interim order.
because already they have passed the order. That order I have challenged before this.
Ex parte order.
ಅವ್ರಿದ್ದವರು
Huh?
kindly see page number 16, your lordship.
Correct. ನಿಮ್ನ ಹಿಯರ್ ಮಾಡಿ ಕೊಟ್ಟಾರ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನನಗೆ ಹಿಯರ್ ಮಾಡಕ್ ಆಪರ್ಚುನಿಟಿನೇ ಕೊಡ್ಲಿಲ್ಲ.
ಅದಕ್ಕೆ ಹೋಗಿ ಹಿಯರ್ ಮಾಡ್ರಿ, ಹೇಳ್ಬಿಡ್ತೇವೆ ನಾವು. This intra-court appeal seeks to call in question an interim order.
Your lordship, once again, even in that day, I appeared through VC That
How this appeal is maintainable? Because of Tamanna. Interim order. Tamanna, 7-judge bench, Tamanna versus Renuka. 7-judge judgment says, if it is an interim order, then no intra-court appeal, ordinarily, subject to some exceptions which we have carved out in Paschim Hindi Prachar antadu ಇದೆ ಅಲ್ಲ, which you had argued. This intra-court appeal seeks to call in question the ad interim order granted by a learned single judge of this court on 6/12/2023 and continued on 10/1/2024 in a pending WP numbers 107017 of 2023 LR connected with WP number 100758 of 2023 LR. First, next paragraph. Learned counsel appearing for the appellant vehemently submits that he is the tenant in cultivation of the subject land, having obtained the grant of occupancy at the hands of the land tribunal under section 48 capital A of the Karnataka Land Reforms Act 1961, and this aspect having not been adverted to, there is a lacuna in the impugned order warranting interference of this court. First, learned HCGP on request accepting for the land tribunal opposes the petition appeal, contending that ordinarily intra-court appeal against interim orders does not lie wide Tamanna versus Renuka. First, he further submits that it is open to the appellant to seek variation of the impugned order at the hands of the learned single judge in the pending petition. New party na?
Oh, not party.
Petition, wherein the appellant happens to be respondent number
2 to 5, your lordship.
2 to 5. Appellants happen to be respondent numbers 2 to 5. First,
257, your lordship.
257, na?
257.
7. First, we agree with this submission. Next paragraph. In view of the above, this appeal is disposed of, reserving liberty to the appellants herein to take appropriate proceedings in the pending writ petition. Please, petition. First, all contentions in that connection are kept open.
Nine, Subhash Tebati.
My lord, the copies are through the WhatsApp.
Caveator, my lord.
He's the filed the caveat, we have filed. And we have challenged the companies challenged the liability as well as quantum in this case, my lord. That insured himself is having no driving license. And
application.
That I'm seeking for a stay because he filed the EP.
Deposit amount, so that it will help you.
My lord,
instead of
yes, my
execution,
lord,
you
withdraw
go to
the
coaching.
amount. Because, my lord, the liabilities, there is no liability question. Pay and recovery is orders. My lord, the amount is, my lord, the 45 lakhs. So, my lord,
Amount deposit ಮಾಡಿ.
the entire amount
My
will be
lord.
deposited. Only
My lord.
quantum is,
My lord, my quantum is also that he was a salaried person. His gross income is 19,000, but our court has considered 29,000 rupees. So
No,
that we have filed appeal in time. Application. No, there is no delay.
my lord.
Requires consideration. There shall be an interim order of subject to appellant depositing 50% of the award amount before the tribunal within a period of 8 weeks. The tribunal is directed to reinvest the said amount.
My lord, let me be permitted to withdraw there is no liability question.
We challenge the liability.
Liability challenge ಆಗಿದೆ.
Emergent notice to Sri BM Patil, response appearance for respond number 1, gave it. Emergent notice to R4.
R1 to R3.
Then we can concurrent, please.
I'm filing memo of facts for dispensation of translated copy.
ಮೆರಿಟ್ ಮೇಲೆ ಏನಿದೆ?
Merits, my lords, that is premature transfer, my lords. The petitioner herein was appointed as attender in the year 2014 under
Tender.
compassionate ground, my lords. And thereafter she was promoted in the year 2022, my lords, 13/6/22. She got promotion, my lords, and now she is working as SDA. Now she has been prematurely disturbed by the state, my lords.
ಏನಂತ KT ಏನಂತ ಹೇಳ್ತಾ?
KT, my lords.
What the KT says, but he was working in the very same place as a attendant.
ಪ್ರಮೋಷನ್ ಇದ್ರೆ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅನ್ನೋದು ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್.
Lord,
ಪ್ರಮೋಷನ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರಾ?
ಇಲ್ಲ promotion will transfer ಮಾಡಿಲ್ಲ. Lord, he was working in from the 2014 in the same place as a Lord project child welfare development officer as attendant. Lord, he was promoted in the year 2022 and working in the very same place.
Yes.
And now he was transferred, my lord,
How? Why?
from that place. Now the KT holder, since he is working from the very same place last 14 years, you cannot say that it's ಅದು ಏನಾಗುತ್ತೆ ಪ್ಲೇಸ್ ಇದಾದ್ರೆ
ಬೇಸ್ಡ್ ಇದೆ ಗೈಡ್ಲೈನ್ 2016 ಗೈಡ್ಲೈನ್ ಯಾವುದು?
ಲಾ ಇರೋದು ಲಾರ್ಡ್ ಇವನ್ ದೋ ಇಟ್ಸ್ ಇನ್ ವೆರಿ ಸೇಮ್ ಪ್ಲೇಸ್
ಸೇಮ್ ಆಫೀಸ್ ಆಲ್ಸೋ.
once ಆತರ
ಚಂದ್ರ ವರ್ಸಸ್ ಸೈನ್ಸ್ ಅಲ್ವಾ?
ಲಾ ಇಸ್ ದೇರ್.
It requires consideration.
But already, my lord, state the other contesting respondent has taken.
No, no. She's
working.
working.
ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದಲ್ಲ ಏನಲ್ಲ ಚಾರ್ಜ್ ಅಂತ ಕೈ ಮಾಡಿ ಕೊಟ್ರೆ ವಾಪಸ್. ಚಾಮುಂಡಿ ಮೆಪೆಡ್ ಅನ್ಸರಿ ಚಾಮುಂಡಿ ಮೆಪೆಡ್
ನಾರ್ಮಲಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ
ಎಲ್ಲರೂ ಹಂಗ ಮಾಡಿಬಿಡ್ತಾರೆ ನಾಳೆ. ಹಂಗ ಮಾಡಕ್ ಬರೋದು.
transfer order.
Direction to restore.
The response 1, 2, 3 are directed to continue the petitioner in the
Not in the.
to work continue the petitioner in the post of SDA at CDPO office at Indore. The respondent number 4 shall hand over the charge and report back to her original post.
ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಪೋಸ್ಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಒರಿಜಿನಲ್ ಪೋಸ್ಟ್ ಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
Post details.
Authority take necessary steps.
ಅಲ್ಲಿ ಮತ್ತೆ ಬರೀ ಯಾರೋ ಒಬ್ಬರು ಬಂದಿರ್ತಾರೆ.
Appropriate.
Lords, on submission, lords, till today, she has not assumed.
Then it's okay.
Full bench judgment ಯಾವುದು?
ಇದು I'll give it, brother. Chandra, last time ಕೊಟ್ಟಿದ್ದೆ. I'll give it.
Chandra is reiterated in by Justice Chauhan Sahib.
Please.
Chandra is by Justice KL Manjunath bench.
I'll give it for this.
Great. Lords, I may be permitted to file memo of facts in the
Memo of
facts, lords, for seeking dispensation.
dispensation.
Please.
Well, on oral request, dispensation granted.
11 Arabirad VG Bhatt.
Or by judgment, my lords. Or by judgment. Same, it is Satur village, my lords. In respect to Andasu, the apex court also given the same findings. Delay may be controlled.
The interest.
After, I'll waive the interest also.
7 ವರ್ಷ delay ಇದೆ. If you agree, we can do. Otherwise, very consequence follow.
On 79, 5 days back, your lordship has in the similar matter.
It all depends upon several factors. Delay is a slippery question.
ಇದೇ ಸೇಮ್ ಇದ್ರದ್ದು ಮಾಡಿದ್ರಿ ಒಂದು ರಿಕಾಲ್ ಮಾಡಿ.
Recalling.
In administered interest.
ಮತ್ತೆ ಇದು ಆಯಪ್ಪ ಕಂಡೋನೇಷನ್ ಇನ್ನೂ ಡಿಲೇ.
ಅದು ರೀಕಾಲ್ ಇದು LR's application.
LR's ಅದು delay.
Accepting the cost shown.
LR's.
Delay of 2810 days. Delay in filing an application to recall the order dated 22/2/2013 condone subject to denial of interest for the said period, including the applicant is not entitled the solution of 30% for the said period.
Please.
Application to set aside the abatement is allowed. Abatement is set aside. The legal heirs of
Appellant number 2.
and number 2 are permitted to be brought on record. Appellant to amend cost item. ಆಯ್ತಾ? ಆದ್ಮೇಲೆ heard on IA 2 of 24. Delay of 3-7 days. ಇದು ಯಾರಿಗೆ?
Recalling.
For recalling the order.
For recalling.
Calling the order.
MFA.
Appeal was dismissed for
Non-prosecution. 2810.
For non-prosecution.
Yes.
7 years.
in similar batch of
Covered by judgment by in MFA, my lord, so 21048.
ಇಲ್ಲಿ 3 ತರ ಕೊಡ್ತಾರೆ. ಫಾಸ್ಟ್ ಆಗಿ ಇವ್ರು ತಪ್ಪು ಬರ್ತಿದಾರಲ್ಲ. ಅದಾಯ್ತು, ಎರಡಾಯ್ತು. IA for city filing the LR's application. ಈ serial number. One of recalling of Karnataka.
Dismissal order for non-prosecution.
Orders on IA 1 of 22, except in the cause shown delay of 2810 days, delay in referring an application to recall the order dated 22/2/2013 is condoned by denying the interest as well as the interest on solution for 2810 days delay. Order dated so and so is recalled. Bill is restored. Two. IA 2 of 22 is filed seeking condonation of delay of
Allah, 1 and 2 are, 1 is for recalling, 2 is for delay in filing the recalling application.
ಮೇಲೆ ಫಸ್ಟ್ ಆರ್ಡರ್ ಬರ್ತಾರಲ್ಲ, IA 1 and IA 2 of 22 are allowed. Next IA 1 of 24 orders. Except the cause shown delay of 2-3-3-5 days, 3 to 3-5 days delay in
Recalling
an application to bring LRs of the application are condoned.
Abatement. Setting aside abatement and.
setting aside abatement and
Oh.
Is condoned by by denying the interest for the said period. Abatement is set aside. LRs of the appellant number 2 are permitted to be brought on the spot. Accordingly, IA so and so are allowed. Appellant to amend cost item. Bill is restored and when the and counsel appearing for the C so and so error.
R1.
R1 state, R2 central government.
The CGP is requested for R1.
R2 myself.
RV accepts notice for this is filed by the counsel appearing for the parties where it submits that this present appeal is heard by the chief of the coordinate bench. MFA 21045 up to 12. Passed in sewer purposes. In view of the said submission, the police disposed of. The compensation is redetermined at the rate of 1,79,390 per class along with outstanding benefits.
Please.
The appeal is allowed pass. It is made clear that the appellant not be entitled for the interest for the period for the 2810 and 3 to 3 days delay, as well as he is not entitled interest on solution for the aforesaid.
Yes.
12, Sunil Desai.
But the case, the respondent is an outdoor employee of the temple. As per Rule 6, age of retirement is 65. So the single judge, my lord, since the act is challenged and pending before the Supreme Court, there is a protection to the archakas for their retirement. In fact, my lord, by relying on that, my lord, continued the service. The respondent has not challenged even the rule. ಈಗ 77 ವರ್ಷ ಆಗಿದೆ ಅವ್ನಿಗೆ 65 ವರ್ಷದಿಂದ ಇಲ್ಲೇ ಒಬ್ಬನೇ
ಕೇಸ್ ಹಾಕಿರೋದೇ ಅಲ್ಲ ನೋಡಿ, ಕೇಸ್
60
ಹಾಕಿರೋದೇ
ವರ್ಷಕ್ಕೆ.
60 ವರ್ಷಕ್ಕೆ ಅಂತ ಕೇಸ್ ಹಾಕಿದ್ರು.
rules you lordships permit us to relieve him a lot, still he is been continuing whatever monetary benefit he is entitled. You can't
ಪರ್ಮನೆಂಟ್ಲಿ ಅಲ್ಲೇ ಇರಬೇಕು, ಬೇರೆ ಯಾರಿಗೂ ಬಿಡಬಾರ್ದು. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಆಗ್ತಿತ್ತು ಹಿಂದಿನ ಬೆಂಚ್ ಅಲ್ಲಿ.
It is submitted that the petitioner has been continued pursuant to the order of the judge, and now he has attained
77 years.
continuation of the respondent number 4, respondent number 3.
Yes.
In the services of the first respondent temple.
Yes.
Is contrary to the
Rule 11 subclass 2.
and requires judicial consideration. In view of the same, the appellant is permitted to relieve
Please.
third respondent of services.
Please.
ಮಾನಿಟರಿ ಬೆನಿಫಿಟ್ಸ್ ಏನು?
ಅದು ಬರುತ್ತೆ, ಅವರು ಬೇರೆ ಕೇಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
13, Mrityunjay Hellikeri.
Lord, this is the appeal by the wife, my lord, against the decree of divorce. My lord, on the last occasion, my lord, my friend filed his memo of calculation. And also, my lord, at the threat of arrest, my lord, he paid 2 lakh rupees, my lord, in check. Now, my lord, according to me.
Presented by the appellant here, and but that was my lord honored your lordships.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಅವ್ರ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ
ಸಂಜಯ ಲೊಕೇಶನ್ ಆದ್ಮೇಲೆ ಮಾಡೋಣ ಇರು.
ಇಲ್ಲ ಮೈ
ಅಮೌಂಟ್ ಬಂದಿದೆ ನಿಮ್ಮ ಕ್ಲೈಂಟ್.
ಸರಿ, ಗ್ರೇಟ್.
One of 2022, matter being of the year 2022. Considering nature of dispute, list the matter in the second week of October.
Please.
Second week of October 2022.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಡೈರೆಕ್ಷನ್ ಇದೆ, ಅವ್ರದ್ದು ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು ಅಂತ, ಸೊ ದಟ್ ಅವ್ರು ಕೊಟ್ರೆ ನಾನು
Respondent undertake to produce the salary certificate on the next day of the hearing.
Please, your lordship.
ಐ ಆಮ್ ಗ್ರೇಟ್ಫುಲ್.
15, government.
New act.
There. Please.
Old act.
No, this was not. 15 mil. 15. Order of the KT, my lord, wherein application filed by the respondent was allowed. His father was, my lord, made an application for retirement, my lord, under the voluntary retirement under Rule 385. That was allowed, my lord, as he is permitted to live. Thereafter, my lord, son has made an application. My lord, early hearing, already matter is admitted and stay is granted. They have filed early hearing.
I am for respondent number 2.
R2.
List third week of October.
16, Ravi Hegde.
Appearing for complainant.
Please, my lord, I filed an application for extension of time. There was a direction in view of the order passed by the government that 1/30th of pay scale is ordered to be payable to casual laborers.
the honorable court dropped the contempt, giving us 2 months time. My lord. Now the process has begun, we required some more time because the consultation with the finance ministry has to.
ಅಲ್ಲ 8 months time ಕೇಳ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ,
Lords may kindness ಇದೆ affida.
ಅವ್ರು ಕೇಳಿ ನಾವು ಕೊಡ್ಬೇಕು.
ಇಲ್ಲ I'm sorry.
ಅವ್ರು 8 ವರ್ಷ ಕೇಳ್ತಾರೆ.
I am sorry.
ಅಡ್ವಿ
ಅಲ್ಲ,
ಅಷ್ಟು ಟೈಮ್ ಅಂತ ಕೇಸ್ ಅಲ್ಲ ಇದು.
ಅಲ್ಲ, department has sent it, I also objected, I'll leave it to lordship, some reasonable time.
3 months ಅಲ್ಲಿ ಎಲ್ಲ ಮಾಡಿ.
ಅಲ್ಲ, please. The process has started in a second week of August.
ಅದ್ನ ಒಂದು ಮೆಮೊ
Yes, madam, affidavit.
ಅಪ್ಲೈ ಮಾಡ್ತೀವಿ ಅಂತ ಎಲ್ಲಿ ಕಂಪ್ಲೈ ಮಾಡ್ತೀವಿ
Yes,
ಅಂತ ಹೇಳಿ
madam, it is in the affidavit itself I filed. Concerned order was sent, paragraph 3, my lord. Order is also passed. I submit that honorable court has given 2 months time from the date of receipt of the certified copy of that. After obtaining the order, the concerned order was sent to Directorate TSI, New Delhi.
ವಿಚ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಯ್ಯೇ
Yes,
ಹಾಕಿದ್ದು.
madam. Yes.
Accused number 1.
Seeking extension of time of 8 months. Comply. Direction to the lens. 5/10/2023, past interview. 5799. Paper and the responsibility for the Kumar Bhatt.
Vinay Kumar.
Counsel appearing for the complaint. Peruse the evidence made in the affidavit. The order dated 19/3, accepting the reasons, considering the fact that there are administrative procedure involved further period of 3 months.
Please.
is rendered. It's made clear that no further
Please.
extension will be considered. Extension is granted, keeping in mind the fact that the respondent has undertook to comply the order of the London.
Yes.
Obliged.
Obliged.
Case disposed of.
ಪರ್ಫೆಕ್ಟ್ ಕರೆಕ್ಟ್ ಇದೆ.
17.
ಇದರಲ್ಲಿ ಫೈಲ್ಡ್ ರಿಟ್ ಅಪೀಲ್ ಮಿಲಾಡ್
ರಿಟ್ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಹಾಕಿದ್ವಿ.
You have filed.
ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್
ಪ್ಲೀಸ್.
18. Umesh Senapur. Passport.
My friend will argue this matter. HM very going to argue this matter, man. Kindly pass over.
224 meter
Serial number 18.
ಏನಿದೆ? ನೋಟಿಸ್ ಆಲ್ಟು ನೋಟಿಸ್ ಮಾಡೋಣ.
Please, notice.
One and two, my lord.
1 and 2.
ಅಲ್ಲ, only two, my lord. One ಗೆ
KPSC, KL Patil, man.
please.
Allowed, dispensation is there, my lord. Dispensation.
Dispensation is allowed for the time being.
Obliged.
19. SK Kakmat.
On IA for maintenance and he has, I have filed.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ ಸರ್, ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು
ಡಾಕ್ಟರ್ಸ್
ಡಾಕ್ಟರ್ಸ್ ಅಲ್ಲ ಸರ್,
ಇದು ಬೇರೆ.
ಇದು ಬೇರೆ ತಾವು ಚೇಂಬರ್ನಲ್ಲೇ ಇದು ಮಾಡಿದ್ರು
ಹಾ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕಂಡಕ್ಟ್
ಏನು ಇದು ಸರಿ ನಡೆದದಾ?
ನಡೆದಿದೆ ಸರ್, ಹೋಗ್ತಾ ಇದ್ದಾನೆ ರೆಗ್ಯುಲರ್. ಏನೋ ಮೊನ್ನೆ ಗಣೇಶ ಚತುರ್ಥಿಗೆಲ್ಲ ಬಾಂಬೆಗೆ ಹೋಗಿದ್ರಂತ, ಈ ಡಿಡ್ ನಾಟ್ ವಿಸಿಟ್, ಅದರ್ವೈಸ್ ಈಸ್ ವಿಸಿಟಿಂಗ್.
ಅಪ್ಲಿಕೇಶನ್ ಬರಲಿ.
ಮೇಂಟೆನೆನ್ಸ್ ಒಂದು ಸ್ವಲ್ಪ
ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅಂದ್ರೆ ಪ್ರೀವಿಯಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಈ ತಿಂಗಳು ಹೋದ ತಿಂಗಳದ್ದು ಕೊಟ್ಟಿಲ್ಲ. ಅದು ಮತ್ತೆ ಒಂದಿಷ್ಟು ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ನಾನು ಕಾಯಕ್ ಮಠದ ಜೊತೆ ಶೇರ್ ಮಾಡಿದ್ದೇನೆ. ಎಜುಕೇಶನ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಒಂದು 67,000 ರೂಪಾಯಿ ಆಯ್ತು ಆ ಹುಡುಗಂದು, ಕೊಡು ಅಂತ ಹೇಳಿದ್ದೆ, ಅದು ಒಂದು ಸ್ವಲ್ಪ ಶೇರ್ ಮಾಡಿದ್ದೇನೆ.
ಕಾಯಕ್ ಮಟ್ರು ಇದ್ದಾರೆ.
ಬಂದಿದೆ.
ಇದ್ರದ್ದು ಮೇಂಟೆನೆನ್ಸ್ ಪ್ಲಸ್ ಒಂದ್ ತಿಂಗಳದ್ದೇನೋ ಇರ್ಬೇಕೇನೋ?
ಒಂದ್ ತಿಂಗಳ
ಒಂದ್ ತಿಂಗಳದ ಮೇಂಟೆನೆನ್ಸ್ ಸ್ಟೂಡೆಂಟ್ ಇದನ್ನ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು ನಿಮ್ ಕ್ಲೈಂಟ್ ಬಂದಿಲ್ಲ.
share ಮಾಡಿದ್ದೇನೆ.
ಹುಡುಗದೇನು ನಮ್ಗೆ ರಿಸಿಟ್ ಏನು ಕಳಿಸಿದ್ದಾರೆ, ವಿಲ್ ಮೇಕ್ ದ ಪೇಮೆಂಟ್ ಆಫ್ ದಟ್ ವಾಟ್.
ಅವ್ರು ಅವತ್ತೇ ಹೇಳಿದ್ರು ಅದಕ್ಕೇನು ಆರ್ಡರ್ ಬೇಡ, ಓಪನ್ಲಿ
So far as maintenance is concerned, madam, she is earning also, it is required to be revisited. ಒಂದ್ ತಿಂಗಳ ಕೊಡ್ತೀನಿ, ಒಂದ್ ತಿಂಗಳ ಕೊಡ್ತೀನಿ. ಅಂಡ್ my lord ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, ಸೊ ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇದನ್ನ ಆ ಬಾಂಡ್ which the father wanted to reunite is not going to happen because every moment she is interfering. ಆ ಮಗುವಿನ ಹತ್ರ ಕೂತ್ಕೊಂಡ್ರೆ ಏನಾಯ್ತು ಅಂತ ಆಗ್ಲಿ ಬಂದು ಇವ್ರೇನು ಹೇಳಿದ್ರು ಹೊಡೆದು ಆ ಮನೆ ಒಳಗೆ ಆ ಅಟ್ಮಾಸ್ಫಿಯರ್ ಕ್ರಿಯೇಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
67,000 ಅದು
67,694.
ಅಲ್ಲ ಅದು 67,000 ಅಲ್ಲ, ಬಟ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತಂದ್ರೆ ಅವ್ ಏನ್ ರೆಸಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾವ್ದು ಅಂತ ನಾನು ವೆರಿಫೈ ಮಾಡಿ ಸ್ವಲ್ಪ ಮೇಕ್ ದ ಪೇಮೆಂಟ್.
ಸಂಜಯ್ ಬನ್ನಿ, ಅದು ಇದ್ರದ್ದು ಪೇಮೆಂಟ್ ಮಾಡ್ರಿ, ಇದ್ರದ್ದು ಎಕ್ಸ್ಪೆಂಡಿಚರ್ ಏನೋ ಇದೆ ಅಲ್ಲ ಸ್ಕೂಲದ್ದು.
ಅಲ್ಲ ಸ್ಕೂಲಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಸ್ಕೂಲ್ ಮೆಡಿಕಲ್ ಒಂದು
ಎಕ್ಸ್ಪೆಂಡಿಚರ್ ಏನೋ ಮಗು
ಅಲ್ಲ ಮೆಡಿಕಲ್ ವಾಟ್ ಆರ್ ದ ಬಿಲ್ಸ್ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಸರ್, ನಾನು ಕಳ್ಸಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಕಳ್ಸಿಕೊಟ್ಟಿದ್ದೀನಿ, ಅವ್ರಿಗೆ ಕೊಡ್ತಾರೆ ಸರ್. ನಾನು ಅದ್ರ ಬಗ್ಗೆ ಏನು ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಡ್ರೆಸ್ ಬೇಡ. Yes, said other.
The bills are pertaining to 2022, sir, 2023.
ಏನೇ ಇದ್ರು ಮಗು ಅಲ್ಲ ಸಂಜಯ್ ಮಗುಂದಿತ್ತು ಅಂತಂದ್ರೆ ಕೊಡ, ಅದನ್ನು ಕೊಡಲ್ಲ.
There is no invoice, sir, just some sort of.
ಯಾರು ಇನ್ವಾಯ್ಸ್ ಮೆಡಿಕಲ್ ನಾಗೆಲ್ಲ ಎಷ್ಟೆಲ್ಲ ಬರ್ತದೆ.
But school, everything I'm ready to pay, sir. And around 28,000 is there with regard to school and the medical expenses, sir. Immediately I'll pay it, sir. That's not an issue, sir.
ನಾವೇನ್ ರೆಕಾರ್ಡ್
Other
ಮಾಡಲ್ಲ.
payments which are nowhere related is what it is.
ಮಾಡಿ,
I'm speaking of.
ಅಷ್ಟು
ಒಂದು ಗುಡ್ ವಿಲ್ ಜನರೇಟ್ ಮಾಡಿ ನಿಮ್ಮಿಬ್ಬರ
ಈಸ್ ಕಮಿಂಗ್, ಬರ್ತಾ ಇದ್ದಾನೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಬರ್ತದ, ಬಟ್ ಏನ್ ಮನೆಯೊಳಗೆ my lord is feeling a suffocation.
His father
he is entitled.
At least he may, at least he may be permitted to take out.
ಬರ್ತಾ ಇದ್ದಾರೆ, ಕುಂದಿರ್ತಾ ಇದ್ದಾರೆ.
ಅದೇನಾಗಿದೆ?
saying I am making, see ಪೂರ unscrupulous ಇತ್ತು ನಾವು ಅಲೋ ಮಾಡೋದಿಲ್ಲ. He has stood tall and he said orders ಬೇಕಿಲ್ಲ, I am making, I has made payment also. Now he is saying that I will make the payment. Accept that payment. Accept that. We will not make the order. ಎಲ್ಲ ಆರ್ಡರ್ ಮಾಡೋ ಅಗತ್ಯ ಇಲ್ಲ.
Until the disposal of the litigation, regular payment, maintenance at least ಕೊಡ್ಲಿ ಸರ್.
ಅದನ್ನ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ರಿ,
ರೆಗ್ಯುಲರ್ ಕೊಡ್ಲಿ ಸರ್.
ಮೇಂಟೆನೆನ್ಸ್ ಏನು ಕೊಟ್ಟಿರೋದು
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ ಅಂತ ಅದು ಐ ಪೇಡ್ ಅಂತ ಯಾವುದನ್ನ ನಾವು ಹೇಳಿದ್ ಯಾವುದೂ ಇಲ್ಲ ಅನ್ನಕತ್ತಿಲ್ಲ.
When parties conduct themselves stall before the court, we will not make adverse orders. We believe the parties. We believe the parties because conduct is like that. We will not make any order. Payment part.
With regard to the visitation, sir, not even once till date have been allowed to go out with my child, sir. At every point we went with for a small issue, ಏನ್ ಮಾತಾಡ್ತಿದ್ರಿ with the child. I feel totally suffocated, sir, there. Because
Court officer, sir. Court officer, sir. ವಿಡಿಯೋ ಆಡಿಯೋ ವಿಡಿಯೋ ಎರಡು ಕ್ಲಿಯರ್ ಐತಲ್ರಿ?
ಹಾ ಸರ್ ಕ್ಲಿಯರ್ ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ಸ್.
Sridhar Prabhu? Yes, Sridhar Prabhu.
My lords, the case is, my lord, that in Hangal town, right in the midst of a town, my lord, there is a land, vacant land. It originally belongs to the government, my lord. In 1931, my lord, the land was held to be government land, and in the PIL filed in 12327 of 2009 also, it is reiterated that it is government land. But two parties, my lord, unconnected parties claiming to be Hindu interest and Muslim interest, they enter into a compromise and say that the land should be equally divided and it should be, my lord, given to them. And prominently, my lord, the dispute goes before the DC at page 68, my lord. An order is passed holding that such kind of a compromise, ad hoc compromise entered into between two unconnected parties cannot, my lord, deprive the state of its land interest. Page 68, my lord, is the order, the operative portion. Your lordships will get from 69 onwards, my lord. May I read it with your lordships, my lord? Page 69, the last but second paragraph, my lord. Vivadita astiyu. Am I reading with your lordships?
Assistant.
Collector, 1931, my lord, passes this reference to that assistant collector. Vivadita assistant collector Dharwad ಇವರಿಂದ 1931 ನಿಂದ ಸರ್ಕಾರಿ ಆಸ್ತಿ ಎಂದು ತೀರ್ಮಾನಿಸಿದ್ದು ಇರುತ್ತದೆ. ಅದಕ್ಕೆ ಆದೇಶಕ್ಕೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಮಾಡಿದ ವಿವಾದಿತ ಥರಾವು ಸೋ ಮಾಡಲು ಅಧಿಕಾರವಿದೆಯೋ ಹೇಗೆ ಎನ್ನುವ ವಿವಾದಾಂಶ ವಿವಾದಿತ ಆಸ್ತಿ ಒಬ್ಬ ಪಕ್ಷಕಾರರು ಒಪ್ಪುವಂತೆ ಸರ್ಕಾರದ ಆಸ್ತಿ ಇರುತ್ತದೆ. ಇದನ್ನು ದೃಢೀಕರಿಸಲು ಅಸಿಸ್ಟೆಂಟ್ ಕಲೆಕ್ಟರ್ 1931ರಲ್ಲೇ ತೀರ್ಮಾನಿಸಿರುತ್ತಾರೆ. ಪುರಸಭೆಯ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯ ಕರ ನಿರಾಕರಣೆ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಕೂಡ ದಾಖಲೆ ಕೂಡ ಆಗಿರುತ್ತದೆ. ಸದರಿ ಥರಾವನ್ನು ಪಕ್ಷದಾರರೇ ಮೊದಲಿದ್ದ ಸೋನ್ಸೋ ಪುರಸಭೆಯ ಸೋನ್ಸೋ 1964 ನಂತರ ಯಾರೂ ವಿವಾದಿಸಿರುವುದಿಲ್ಲ. ಮೋರ್ ಇಂಪಾರ್ಟೆಂಟ್ಲಿ ದ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಮೂರನೇ ವಿವಾದಾಂಶ ದಿನಾಂಕ ಸೋನ್ಸೋ ಆದೇಶದ ವಿವಾದಿತ ಆಸ್ತಿ ಸರ್ಕಾರದ ಆಸ್ತಿ ಎಂದು ನಿರ್ಣಯವಾಗಿದ್ದು ಆಗ ಇದ್ದ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ನಂತರ ವಿಲೀನ ಆಗಿರುತ್ತದೆ. ವಿವಾದಿತ ಆಸ್ತಿ ಸರ್ಕಾರಿ ಆಸ್ತಿ ಎಂದೇ ಉಭಯ ಪಕ್ಷಗಾರರು ಒಪ್ಪಿ ಅದನ್ನು ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ಗೆ ಕೊಡಲು ಮತ್ತು ಎದುರುದಾರ ಕೋಟಿಗೇರಿ ಮಸೂದಿ ಮಾಲ್ಕಿಯ ಆಸ್ತಿಯನ್ನು ಕೂಡ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಹಾನ್ಗಲ್ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ಗೆ ಕೊಡಲು ಠರಾವು ಮಾಡಿದ ವಿಷಯವು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿ ರಿಟ್ ಅರ್ಜಿ ಸೋನ್ಸೋರಲ್ಲಿ ಎರಡನೇ ಪ್ರತಿವಾದಿಯನ್ನಾಗಿ ಸೇರಿಸಲ್ಪಟ್ಟ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾವೇರಿ ಇವರಿಂದ ಬಂದ ನೋಟಿಸ್ ಸಂಗಡ ಕಳಿಸಿದ್ದ ರಿಟ್ ಅರ್ಜಿ ಸೋನ್ಸೋ ಸ್ಪಷ್ಟವಾಗಿರುತ್ತದೆ. ಆದರೆ ಈ ವಿಷಯವನ್ನು ಎದುರುಗಾರರು ಈ ಪ್ರಕರಣದಲ್ಲಿ ತಿಳಿದು ಬುದ್ಧಾಪೂರ್ವಕವಾಗಿ ಮುಚ್ಚಿಟ್ಟಿರುತ್ತಾರೆ ಎಂಬುದು ಸ್ಪಷ್ಟವಾಗುತ್ತದೆ. Let's stop here, my lord. Now this order, my lord, says that ಮೇಲ್ಕಂಡ ಪುನರ್ನಿರೀಕ್ಷಣ ಮೇಲ್ಮನವಿಯನ್ನು ಅಂಗೀಕರಿಸಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಸಮನೂರ್ ಇವರ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಸೋನ್ಸೋರನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಆದೇಶವನ್ನು ಗಣಕಯಂತ್ರದಲ್ಲಿ ಸರಿಪಡಿಸಿ. That, my lord, is the order. That the land is, my lord, declared to be government property. This order is impugned before this honorable court, before the learned single judge, my lord. The learned single judge conducts an inquiry into the title at page, my lord, 18 onwards. Your lordships will find the impugned order. More particularly, my lord, this is digested. Lordships may see page 24, the one which I read, my lord, being aggrieved by this order of the assistant commissioner, page 24, para 9, my lord. An appeal was preferred to the deputy commissioner once again in section 305-306. Deputy commissioner in this appeal, the view that there was an order dated 31 by the assistant commissioner Dharwad, the assistant collector Dharwad, in which it has been stated that property belonged to the government and this order has not been challenged by anyone and consequently the property clearly belonged to the government and therefore the entry in favor of so and so was improper. This is not noted, but kindly see the final decision, Lord, at page 38. There is a specific finding with regard to this 1931 order, my lord. Para 36, page 38, my lord.
Yes.
As far as the contention that in the year 1931 there was a decision taken by the assistant collector that property belonged to the government is concerned, it is to be stated here that there was absolutely no material to show the entries in the municipal records stood the same in the government entry up to 79. If the entries in the records were not standing in the name of the government from so and so for 68 years and was inserted in 79, that too without any basis, it is clear that government had never claimed the property belonged to the so and so. I have 3 submissions to make, my lord, if lordships permit. Sorry. Ladu, 68, 82 nallu power ide anta DC. That's all, my lord, I am submitting. That section 82, it is covered by a decision of this honorable court that instead of 306 nalli power, emergency power, adan ee riti adjudicate ಮಾಡ್ಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿ, that is, my lord, the crux of the single judge's finding. But may I pass on, my lord, the judgment passed by this honorable court on 20th February 23, wherein it says, may I, my lord, pass on, my colleague is there, my lord, in the court. May I, my lord.
My judgment.
No, my lord, it is by Honorable Justice S.G. Pandit, my lord. The single judge, I'm sorry, my lord, I'm quoting that judgment. It is precisely on the point, therefore, my lord, has persuasive value, my lord. May I persuade your lordships to see internal page 9, my lord, para 7. Very identical facts. It is the case of the respondent and 5 and 6, respondent number 5 and 6. Para 7, my lord, am I reading with your lordships? The Tahsildar that the land in question is Gram Thana land belonging to the government. If the so-and-so claim ownership or title to the interest of the property, it is for the municipal council to approach the competent authority under section 82 and they extract this. Then, my lord, para 8, subsection 1 of 82 makes it clear that any property or any right in over any property is claimed by or on behalf of the council or by any person against the municipal council. It shall be lawful for the DC after inquiry of which due notice has been given to pass the order deciding so and so.
Deciding the claim.
Please. So, my lord, 82 nalli, this order, that is, my lord, that was impugned before the learned single judge, is also an order under 82. He may have stated, my lord, 306. But if anybody claims the government property, municipal property, and claims a title against the property,
the rate of any other cost with the final of the shall be dismissed, although limitation has not been set up by the section 3 limitation ಈ ರೀತಿ section ಮಾಡಿದ್ದಾರೆ.
my lord, now the state also, my lord, does not challenge the learned single judge's order. We are poor, my lord, devotees, Grama Devata, lord, temple devotees. There is a Padagatti in 1931 order itself, my lord, that Padagatti is also mentioned. My lord, that order is at page 248, my lord, where 1931 collector's order is also part of the record. ಆ ಪಾದಗಟ್ಟಿ ಇದ್ದಿದ್ದನ್ನ ಆಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅನ್ನು ಎಲ್ಲವನ್ನೂ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿ ಈಗ ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೊರಟಿದ್ದಾರೆ. But 248, your lordships will find the 1931 assistant collector's order, which is not disputed. Lordships may see, Lord, the specific reference to the Padagatti at page 3, internal page 3 there too. Lord, only Dyamava Padagatta, Lordships will find it, Lord, in the middle of that paragraph. Internal page 248 onwards, my lord, is the order of the assistant collector, which is, my lord, now, sorry, my lord, it should have been part of the lordships get it.
248.
248, my lord. That along with the memo, that order is produced in the learned single, before the learned single judge, my lord. Idralli, Mr. Kadkol, who was Mamlatdar Hanagal between 1926 to 29. I'm sorry, my lord, if I'm not able to assist your lordships on exact page numbers. There is, my lord, a memo and assistant collector's order.
As between two communities.
Yes. Now, Lord, it is now the collector clearly holds that there is a Dyamava, seat of Dyamava at the time of Jatra. The Jatra is held in the northeast corner at Tree and Katta. In the southwest corner were to be seen. For many days, things went smoothly in the matter and use of the site by the owners and the public buses. A dispute then arises between so-and-so communities as to the ownership of the site. None would come forward and claim the site had any notice had to be issued for clearing the site and maintain its sanitary condition with use of site as motor stand. Attraction of the people increased towards it. Amele, I decided that the site belonged to the government. The garage and site should be allowed to stand on payment of occupancy price and rent, and Mamlatdar should submit encroachment statement. Now, Lord, ಅಲ್ಲಿ ಹೋಗಿ ಇವರು ಗಾಡಿಗಳನ್ನು ತಳ್ಳು ಗಾಡಿಗಳನ್ನು ತಗೊಂಡೋಗಿ ಒಂದ್ ಸ್ವಲ್ಪ ದಿನ ನಿಲ್ಲಿಸಿ ಆಮೇಲೆ ಇದು ನಮ್ದೇ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿ ಮಾಡಿ ಕ್ಲೇಮ್ ಮಾಡಿ ಈಗ ಅಲ್ಲಿ various kinds of religious structures, my lord, are being constructed. and state does not file appeal, my lord, we are poor people. We waited for the state to appeal because their interest was primarily affected. Then, my lord, with delay we have filed it. I'm only praying, my lord, the single judge's order to be stayed and, my lord, no construction activity to be carried out. I'm sorry, my lord, the delay. Annexure, the IA for stay, Lord, is that
delay is there, na?
how did this? I understand, Lord. I bow down. If state now then a state interest component, nangu namsi now appeal ನೀವು ಇದು ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ. Then, my lord, the state chooses to be, my lord, complacent in the matter. I understand, my lord, notice ಬರಬೇಕು ಆದ್ರೆ ಇದರಲ್ಲಿ in the special circumstances, my lord. At least, my lord, some protection.
Counsel appeal to the appellant. To emergency notice on higher 24 as well as May. The appellant submits that. By virtue of the interim order, by virtue of the final order of the legislature dated 15/12/2022. The who are putting up now construction?
Sorry, my lord, that is by first respondent, the
Point numbers?
First respondent, my lord, first respondent, my lord. And first and second respondents, my lord, I'm sorry. First and second respondents.
Trying to change the nature of the property by putting up construction. He has taken us to the certain documents which indicate that the property is government property. And requires detailed consideration. There shall be matter requires detailed consideration. Stop. If the interim order is not considered at this stage, the third party interest may come in considering the said submission. We are of the considered view that the parties to maintain status quo till next date of hearing.
Grateful.
Regard the position and nature of the property.
Great. My lord, My lord, hand.
It's
May I?
requested to accept notice for
1, 3, 3, 2,
3 to
5.
3 to 5. Yes.
My lords, may I request a copy of hand delivery?
Today we look at it.
Obliged.
Yeah. 2:30 matter. Further hearing.
I appear for the appellant in this matter.
My lords, with your lordships, kind leave, my lords. My lords, before learned senior commences, my lords, with your lordships, kind leave, my lords, I filed a memo to delete the HDMC as intervener, my lords, in this matter.
Which
45.1, 2 and 3. The memo is placed at serial number 45, my lords.
serial number 45. Yes, Nayanatara.
My lords, in this matter, my lords, initially the HDMC was sought to be impleaded, the Hubli-Dharwad Municipal Corporation. Thereafter, my lords, they were placed as interveners, my lords.
You are not a party, you are only an intervener.
Please, my lords, now I filed a memo, my lords, to withdraw even as an intervener. My lords, I pray that memo I may be permitted to press that memo, my lords.
Vikram?
I have no objection.
No, we had made that application.
because of your lordship will recollect An the intervener is not a party to the proceeding. not a party. No, I had made an application to implead them. Then your lordship said let them be permitted to intervene. But in any event, not if they don't want to intervene, then let them. They can leave. The fourth, the HDMC neither, the Hubli
Please, Manoj.
Municipal Corporation has moved a memo seeking its deletion from array of parties. First, panel counsel appearing for the corporation submits that an intervener is not ordinarily treated as a party eo nomine to the proceedings, and that her client's presence even as an intervener is not warranted in the matter. First, this court, by order dated 29/8/2024, had permitted HDMC to be treated as an intervener. Is stripped. First, the perusal of the records coupled with the submissions made at the bar hitherto convinces us that the HDMC need not continue as an intervener also, since they were not parties to the proceedings, any of the proceedings earlier. First. Next, in view of the above, the HDMC is deleted from the cost item, and that it shall no longer be treated as an intervener. First off, petitioner, the appellants to delete, appellants to amend the cost title accordingly right now. Okay.
I'm deeply grateful, Manoj.
Yes.
May I request your lordship to kindly take writ appeal 100.
Just freshen up our memory, just few Yes, words. Yes. Yes. My lord, this your lordship will recollect is a set of employees. Lord, originally, my lord, water supply to Hubli and Dharwad was being done by the municipality. Then, Lord, they decided that the Karnataka urban water supply. Yes. You say that the abolition of contract labor issue you have raised, number one. Number two, you have never issued any appointment order to these people. It was hiring of services, although in contravention of the act. Other day, these are the submissions you made. No, I had pointed out that even if it is in contravention, there is no automatic regularization. But I pointed out, my lords, that there is no violation as well, because the entire work that was given was work given to various contractors to carry out piecework or certain specific identified work. It was never for hiring of people or any kind of manpower contract which was entered into with anybody. I went on a demurrer and said that even if I'm in violation of the Contract Labor Act, the law is that there is no automatic regularization or absorption. And which is why, I pointed out to my lords, your lordship will recollect the three judgments, SAIL, BHEL, which is the latest, which examined this entire issue and set aside the law which existed earlier, that abolition of contract labor is equivalent to regularization. That cannot be. That was the earlier law. That, my lord, was altered. But more importantly, my lord, the finding of the labor or the industrial tribunal was specific. The finding is because there is abolition, therefore the contract is a sham. Supreme Court says you have to make a finding of sham, nature of the contract, and has laid down the various guidelines which must be examined by the industrial tribunal of the labor court to come to a conclusion that there is shamness in the contract. That has not been done by the labor court, nor, my lord, has that been done by the learned single judge. Para 30 of the judgment, your lordship will recollect, my lord, is the only paragraph extracted, and that paragraph only refers to the Gujarat High Court judgment of 1995, where the Gujarat High Court simply said contract labor has been abolished, therefore this entire transaction is a sham, and therefore you become employees. That is in the teeth of the judgment of the Supreme Court in SAIL. There is no specific finding on shamness. That's a fact. Gujarat High Court judgment was anterior to the judgments of Apex Court. Yes, ma'am. Gujarat High Court, of course, the law at that point in time seemed to favor that interpretation. That was not carried to the Apex Court. I'm not sure, I don't find anything.
It was, my lords, and it was set aside, I think, in Dinanath's case. I'll take my lords through it.
That judgment is set aside.
That Gujarat High Court judgment was set aside, but then subsequently it was clarified another judgment. I'll take my lords through it. May require some detailed. If, my lords, if I could request your lordships to kindly take writ appeal 100-152. But of course, my lords, I think my learned friend had already commenced the other day. If your lordships permits, I'll submit. Because I think it was midway
All
through
these
submission.
matters identical issue, na?
Almost identical.
The only
Yes,
issue.
identical issue.
In the last paragraph, the learned judge, the tribunal mentions Gujarat judgment.
Correct.
And therefore it says that they are entitled to absorb.
That there's a nature of employer-employee relationship, and therefore all the consequences will follow.
All right. We are asking you now.
Yes.
What are the indicia to decide there is employer-employee relationship?
That is laid down in BHEL. No, there's no doubt. But in fact, what I would like to submit is this. The entire line of judgments, and I'll take my lords through it. And in fact, what I intend to do also is take my lords through some relevant provisions of the Contract Labor Regulation Act to put all of those provisions in perspective. But in short, my lords, in a sentence, what my endeavor would be is to show your lordships that the moment a Section 10 notification is issued, abolishing contract labor in a particular establishment or qua a particular operation or a process. Subsequent to that, Mr. Chinnappa is absolutely right. There is no question of automatic absorption. SAIL says so. There's no two ways about it. But at the same time, once a Section 10 notification is issued, my respectful submission would be after that, there is no question of going into whether it's a sham or not, simply because in fact, SAIL itself clarifies that the moment a Section 10 notification is issued, the contract labor is abolished, the contract is nullified. Therefore, after that, I don't need to show any shamness. If as in the facts of this case, after the Section 10 notification, in fact, some of us, in fact, the vast majority, at least in my case, were hired after the Section 10 notification. So I asked myself, on what basis? Could it have been done on the basis of a contract, sham or otherwise? It can't be. Simply because, the effect of a Section 10 notification is that there can never be contract employment post the issuance of the notification. So therefore, if there cannot be contract employment, then what's left? It's an automatic relationship of employer-employee. You might call it, it might be through a contract, but I don't need to prove shamness then, because Section 10 abolishes it altogether. But the contra effect to that would be that the management cannot be permitted to hide behind the cloak of a admittedly illegal contract. Let's assume there is a contract in this case. Post Section 10, there cannot be such a contract would be my first submission.
Why are you using the word contract?
Because that is what
Once you say contract is defined.
Correct. No?
Contract is an agreement enforceable by law. Section 2.
True. No, I'm loosely using the word contract because that is what the management is saying.
In fact, in one judgment, we were told during our college days, Professor D. Ramchandra of our Dharwad College used to say, in Mohri Bibi versus Dharwad Ghosh, 1921 pre-council perhaps. Pre-council said, a minor's contract is vide ab initio. Then professor used to say, why
Why is
frequently
it a
called it as a
contract then? If it's what I've been issued, correct, that's right. Now, of course, I'm loosely using the word. So that is the gist of my, that would be the gist of my submission. So I don't need
That,
to.
that judgment of the apex court, where the idea of shamness, etc.
Correct.
which Mr.
BHL,
mentioned,
BHL, that's right.
that was a case where there was no 10.
In fact, to the
notification.
contrary, there is a finding, I'll point out that out to my lords. There's a finding that that particular establishment was exempt from the operation of a Section 10 notification. So the question of the effect of a Section 10 notification never arose for the Honorable Supreme Court's consideration in BHA. As a consequence, then the Honorable Supreme Court had to then go into whether it's a sham contract or not. Then various parameters were laid down. But my respectful submission is this: the moment a Section 10 notification is issued, the question of shamness, the question of subterfugeness will never arise, because there can never be a contract thereafter. And if there is any employment, it has to necessarily mean a principal employer to the employee, that relationship must exist without an intermediary, because the moment an intermediary comes in, it falls follow Section 10. I don't need to prove that once a Section 10, don't.
Not a case of shamness at all.
It need not be. It need not be would be my respectful submission, in light of the fact that there is admittedly a Section 10 notification. Again, my lords, I caveat that with the fact that, let us assume, my lords, although the facts are not, let us assume that the moment the Section 10 notification was issued, this was in November 2006, the management said, please, all of you, thank you very much, please go home. Could I have then asserted that as a matter of right, I'm eligible for absorption? The answer is no. But what did the management choose to do? The management chose to not only continue the services of those people who were already in the employment, but in fact went 2 steps further and employed the vast majority of the people after the notification. So I asked myself, could it have been done by way of a contract? It cannot be, because there's admittedly a Section 10 notification. If it's not by way of a contract, then how else would it be? Then the answer can only be by way of a direct relationship of employer and employee. Then that once that is established, then my lords, then the necessary consequences would follow. So what Mr. Chinnappa is arguing is that there is no finding of the industrial tribunal regarding the shamness of a contract. I would submit that there is a finding possibly on the Gujarat High Court judgment. Maybe to that extent also I will be able to convince my lords, but yes, I admit that I have the mountain of sail to climb as far as that is concerned. But there is another judgment, even where there is no Section 10 notification, and there is no, where I have to assert shamness. Even then, my lords, I may be able to convince my lords. But here in the fact specific, the facts that are specific to this case, the moment Section 10 is issued, I don't need to go into shamness at all. There can't be a contract. So which is, can I just request my lords, just a very few facts, then I'll trouble my lords reading some of the provisions of the Contract Labour Regulation Act, some of the early judgments, not too many, but I won't overburden the court, but then most of the judgments early on related to the competing interests between the management and the labor vis-a-vis shamness. The management would say, there is no relationship of employer and employee between me and the employees. There is a contractor in the middle. The issue then would be, is that contract a sham? Is it just a mere subterfuge? In which case, courts have said that the veil can be pierced. Now, those were the main line of judgments initially. Then, of course, Section 10, if there is a Section 10 notification, sales seems to hold the field, but only vis-a-vis whether there is automatic absorption or not. So if I may just trouble my lords, this is some of the dates. Now, as far as this case is concerned, my lords, I think first important date would be 2nd of November 2006. Now, that is the notification issued under Section 10. Yes. 2/11/2006, gazetted on 10/11/2006, whereby the government of Karnataka, which is the appropriate government, abolished contract labor in all the major corporations, including
2/11/2006.
2/11/2006. That's right.
Yeah, you mean to say the idea of shamness,
yes, ma'am,
does not arise where there is Section 10 notification?
Correct, ma'am. Correct. Because there cannot be a contract. That's why. Shamness, where does the question of shamness arise? Let us say there is no prohibition. There is a of course, there's Section 7. Let us assume there's registration, all that aside.
So that will be an agreement to defeat the purpose
Correct.
of law.
That's right, Mark. In which case, the courts would then have to necessarily.
23, Section 23,
That's right.
Contract Act.
So there the courts would have to necessarily give a finding that it's a sham transaction. Actually, the true nature of the relationship is a direct employer-employee relationship. This contract in the middle is merely a subterfuge or a camouflage. Therefore, I will pierce the veil and draw a direct relationship. In fact, Justice Krishna's one judgment is there. I'll just take my lords through it. Although it may not arise in the facts of this case, for the sake of completeness, I'll just take my lords through it. Now, in the facts of this case, my lords, at least as far as writ appeal 100, 152, I'm instructed to submit, my lords, a number of workers, at the total about 150 employees. I can't put a finger on the exact number, but let us assume about maybe 30 to 40% of those employees were employed on the date of the Section 10 notification. They were continued. And then continued, and about 60-70% were subsequently employed. Now, when the claim was first raised, the claim was first raised in 2009, where we had worked for between 4 to 5 years by then, sometime between 2004 to 6, about 3 to 6 years, various employees had worked. A claim was raised that you have continued my employment. The employment I'm doing is of a perennial nature. You can't continue this on an ad hoc basis. Please regularize my employment by giving me equal pay for equal work as is given to the regular employees. Now that was my first claim. Now, as far as after the mediation failed, my conciliation failed, it was referred under Section 10(1)(d) to the Industrial Tribunal. Now the Industrial Tribunal has raised two issues. Possibly the issue that I am raising today, admittedly, was not raised at all for whatever reason, whether Section 10, what is the effect of Section 10. But first issue was whether it's a sham transaction, whether it's a bogus transaction, in which case do I need to pierce it? Two, if so, can the employment of all these employees be regularized? These were the two issues raised before the Industrial Tribunal. Now, the Industrial Tribunal gave three findings. One is relying on Gujarat High Court. I'll just take my lords through the. Was at the subject to your lordship's permission, was at the end of my arguments. Could I just pass on some written submissions? All of what I'm saying has been encapsulated, including whenever your lordship says. Thank you. Other side you could say. It seems a little verbose, but that's because various extracts are there. Otherwise, it's not. No problem.
My learned friend can be kind enough to possibly
Yes, no, of course.
Send it to me by WhatsApp. It will be helpful.
WhatsApp, I'll share it. I'll share it. Sorry. No, I honestly didn't think we're going to give it right now. Yes, I'm sorry.
Whenever you and Dan come here, we have to do a lot of Dan here.
I'll do that twice then, Lord.
No, in fact, to be in all honesty, Dan and I were quite looking forward to coming together last week. It's a good escape from Bangalore, but unfortunately, I fell sick. No, in fact, I was just referring to para 2.7. What's up, Lydia?
1 and 2.
Yes, yes, that is para 2.7.
What you say is issue 1 should not have been raised at all, going by your version.
Need not have been, possibly because that was a more nuanced.
Only in the absence of 10.
That's right, in the absence of Section 10. And the second question was whether it should be regularized. Now, my lords, if my lords were to kindly see paragraph 2.8, 3 findings were given.
1 second. You mean to say that not recognizing them as employees of the appellant body amounts to giving effect to an agreement which would defeat, if given effect to, would defeat the purpose of law.
100%. I couldn't have put it better. That's all. When the statute prohibits something, the management cannot now be seen hiding behind the cloak of an admittedly illegal, impermissible contract.
Admittedly, new content model. Lawfully.
They can't.
Mr. Dan,
they're
what
not
do you
denying
say?
Section 10.
You were after notification, 10(1) notification. What is the status of arrangement which you had with the contractor?
There, my lord, the answer is there in sale. There are two parts. One is employed prior to the notification. Second is employed after the notification or continued after the notification. The answer is
that even if it is continued after the notification, it may be in violation of the Contract Labour Regulation Act, but the finding has to be whether the contract is a genuine contract. No, that question will not arise. Arises because if my lord looks at the judgment in sale, one paragraph only, the entire answer is there at page 63 of the judgment, para 6. This specific question which my learned friend is raising is answered. I had given your lordship, my lord, a gist of citations. This is the answer which is given by the Honorable Supreme Court. But those are not the cases where 10-1 was issued. 10-1 was issued. 10-1 was issued. But that was a central.
Sale it was issued.
BHA also. 10-1, my lord, was a specific question which arose there.
Sale,
what the apex court says?
If I could draw my lord's attention to para 68, my lords. I'll just read it out, my lords. In our view, the consequences following on the issuance of a section 10 notification are: 1, contract labor working in the establishment at the time of issue of notification will cease to function. So contract labor as on the date of issuance of notification will cease to function. That's point number 1. Point number 2, the contract of
What is meant by contract labor ceases to function?
That's right. Basically means that if there was any contract employees as on the date of the issuance of the section 10 notification, that contract employment cannot proceed any further because there is a prohibition, there's a statutory prohibition in place.
So the services cannot be hired at all?
Cannot. In fact, they would be entitled to ask me to leave the very next day. That is exactly what happened in sale. Now, what happened in sale was that the workman then said, I'm eligible, since the section 10 notification was issued, I was in employment on that day, albeit on a contract basis. I am eligible for automatic absorption. That was the ground raised in sale. Supreme Court said, no, you're not eligible for automatic absorption. Correct. You can't claim regularization or absorption as a matter of right merely by happenstance of issuance of a section 10 notification. But the facts of this case are different. What the management or the board chose to do was not to terminate me.
No,
they chose to continue me. Yes.
Your employment is bad because of 10-1.
Correct. Yes.
Your continuation in employment will be equally bad because of 10-1.
No, my continuance in service on a contract basis would be bad by issuance of section 10. There is no, the management can always continue me on a permanent basis. It's their choice. I can't assert it as a matter of right. But here, that's what I'm saying. Just to put a small nuance on what your lordships rightly said. There is no continuance of employment, but continuance of contract employment, one section 10. So that doesn't mean that they cannot choose to continue to employ me, which is what they did over here. In fact, they employed me subsequent. My lords, may kindly see this, the provisions. I just want to take my lords through. If my lords are seeing the Contract Labour Regulation Act, my lords may first see the statement of objects and reasons. Now, in fact, the object is twofold. It is not merely to abolish contract labor. My lords may kindly see the objects and reasons. An act to regulate the employment of contract labor in certain establishments and to provide for its abolition in certain circumstances. So therefore, my lords, just pausing here for a moment.
One is
regulation and 2 is abolition in certain circumstances. Now, why the legislature thought it fit to do this is for the simple reason that the legislature was well aware of the fact that there cannot be a blanket ban on contract employment. Because some sectors, some industries are heavily reliant on contract labor. They may be seasonal in nature. I'm just giving an example. Let us say coffee plucking in the estates. Now you can't have permanent employees because the coffee plucking is only done during a certain time of the year. You can't ban contract employment in such cases.
2 classes of employments.
Correct, madam.
Those which which the parliament intended to regulate.
Regulate.
And those which the parliament intended to
abolish. Now, in fact, the parliament also laid down parameters which the appropriate government has to consider when deciding whether to abolish or not. That, my lords, we will find in section 10.
Now, the section 10 is abolition.
Abolition.
Regulating section.
Section 7 is the registration.
Which regulates.
Yes, my lords.
Section 7.
Section 7, my lord, the chapter 3 relates to registration of establishments employing contract labor. So every principal employer, my lord, has section 7, to which this act applies, shall within such period as the appropriate government may by notification in the official gazette fix in this behalf with respect to establishments generally or with respect to any class of them, make an application.
Once it is registered, what are the consequences?
Well, they are bound by certain sections of the license itself. Now, section 12, section 12. 23, no?
23.
Contravention, any provision is
Well, other contravention.
No.
No, my lords, may kindly see, chapter 5 takes care of welfare and health of contract labor, which includes what facilities to be provided to them, liability of the principal employer, and who shall be responsible for payment of wages. That is under chapter 5.
To whom this act applies?
It applies to various establishments, my lords.
Where is the application clause?
Yes, I'll just read it. Section 1, subsection 4, my lords. It applies to every establishment in which 20 or more workmen are employed or were employed on any day of the preceding 12 months as contract labor. B, to every contractor who employs or who employed on any day of the preceding 12 months, 20 or more workmen.
The word establishment is defined?
Yes, my lord.
Any office or
Subsection-
department of the government or local authority, so and so.
Or any place where any industry, trade, business, manufacture, or occupation is carried. It's very, very wide in scope.
Whether it is industry or not,
Yes, ma'am.
it would fit into
I don't think that's in.
one.
Yes,
So
ma'am. It
you
will probably
fit
fall
into
under
government or
industry.
local authority.
Yes, ma'am. Or in fact, in this case, it could be a local authority also because it's a water supply board.
Once it applies to any establishment, what are the consequences?
No, just before that, my lords, could I take my lords to section 10? What are the parameters the parliament has laid down when considering whether to abolish or not?
No, two things.
Yes,
Abolition is the second object
yes, ma'am.
in the object.
No,
which you have
actually,
laid
no,
down.
I would say they're parallel objects. I don't think there is any primacy to either of the objectives. I think the primary objective was to ensure that there is no contract employment wherever possible, but wherever it is not possible to abolish it, we will regulate it. That seems to be the, and in fact, there's some judgments which say that also. In fact, the original, when this act was enacted, it was immediately brought under challenge. The Honorable 5-judge bench of the Honorable Supreme Court clarified what the object of section 10 also is. I'll take my lords through it. Now, if my lords were to see section 10, this will throw light on what are the parameters to be considered, my lord. I'll just read section 10, my lord, subsection 1. Notwithstanding anything contained in this act, the appropriate government may, after consultation with the central board or as the case may be a state board, prohibit by way of by notification in the official gazette, employment of contract labor in any process, operation or other work in any establishment. I'll just pause here, my lord. So the prohibition is qua process, operation or any other work in an establishment. So it has to be an establishment, and the prohibition can be qua any process, work or any work in that establishment.
It's nothing but prohibition of employment only.
Yes, but contractor, absolutely. So the effect of section 10 would be that the moment a notification is issued, qua a particular establishment, qua a particular line of work, no contract employment can be employed thereafter. That is the effect. Now kindly see my subsection 2. Now this will explain what are the parameters. Now before issuing any notification under subsection 1 in relation to any establishment, the appropriate government shall have regard to the conditions of work and benefits provided for the contract labor in that establishment and other relevant factors such as whether the process, operation or other work is incidental or necessary for the industry, trade, business, manufacture or occupation that is carried on in that establishment. B, whether it is of a perennial nature, that is to say it is of sufficient duration.
These are only factors which the government has to keep in
when issuing a section 10. Absolutely.
Issuing the notification.
So only for the sake of completeness. I don't think anyone's disputing the section 10 in this case.
whether any literal interpretation is adopted by the courts or any other meaning is attributed to this section.
If my lords were to
How
kindly
courts
see,
have interpreted, how various high courts in the country have interpreted this provision.
generally speaking, my lords, the act itself being a social welfare legislation has been interpreted in the widest possible amplitude. Now, I'll just give a couple of judgments, my lords. One is when I was saying Gammon India, as soon as the act was enacted, various provisions of the act were brought into subject matter of challenge.
Just I want to know.
Yes.
We want to know, what is the effect of this notification?
Effect
Two
of?
things.
Yes, madam.
Effect of this notification is all those who have been employed on a contract basis
Correct.
shall be discontinued.
Yes. Yes.
Correct?
Correct. And the contract itself, so to speak, shall stand dissolved because there can't be a contract thereafter.
Contrary to this.
Yes.
No, it's a contract becoming void.
Correct. No, that is answered absolutely. In fact, your lordship's questions are answered squarely in SAIL, my lords. That is, as I was reading para 68 in SAIL. Exactly the question your lordship asked. So I don't need to paraphrase it. The Supreme Court itself has said so, rather than me trying to interpret what the Supreme Court has said. It is answered in explicit terms. Para 68, SCC page 43. SAIL. Page 43 of the SCC version.
Sale the
Copy, copy. I thought, sorry, last week, Dhyan had given it. So
Our compilation idu. Yes. I have given it, Lord. My compilation is the first judgment. At page 43 of the
43.
compilation which I have given you, Lordship. Page 42 it starts, para 68.
Which paragraph, Vikram?
Para 68, my lords, at page 43, in our view.
Yes.
In our, just above in our view, the following consequences follow on issuing a notification under section 10(1) of the CLRA. 1. Contract labor working in the establishment concerned. My lords, has it?
Yes.
Contract labor
Working in the established concerned at the time of issue of notification
will cease to function. So contract labor will cease to function. Not employ, as your lordship pointed out some time ago, the employment will not cease to function. The management could always choose to continue, but the contract labor will cease to function. So the labor that is employed on a contract basis will cease to function by way of a statutory fiat. The moment the notification is issued, contract labor cannot be permitted to continue. Point number 2, my lords. The contract of principal employer with the contractor in regard to the contract labor comes to an end. So if there is any contract between the principal employer and the contractor, that comes to an end.
What is meant by first?
First point, contract labor working in the establishment. So if there are any employees working on a contract basis, the contract labor ceases to function.
Yeah, what is meant by that?
What is meant by that is this, Manoj. So if there are any employees who are working on a contract basis on the date, they can be asked to go home. That is what SAIL actually says. They can be asked to go home because I don't have any right of automatic absorption.
They can be allowed. They have to go home.
Possibly, Manoj.
Because next is prohibitory.
Correct, because there can't be any contract.
They cease to function.
They cease, exactly. So the contract labor ceases to, the word is cease to function. Then point number 2, my lords, the contract itself comes to an end.
So the contract withers away.
Yes, the contract with that is point number 2. And then point number 3, no contract labor can be employed by the principal employer in any process, operation, or other work in the establishment to which the notification relates at any time thereafter.
So first one is existing. The second part is
contract will dissolve. Third is you can't engage contract labor afterwards.
Prohibition.
Absolutely.
Fourth
is the contract labor is not rendered unemployed as is generally assumed, but continues in the employment of the contractor as the notification does not sever the relationship of master and servant between the contractor and the contract labor, of course. So that I continue the employment of the contractor.
So with this organization, you cease to be.
Yes. On a contract basis, I cease to be. Now, which is why
continue to be the employees
of the contractor. Yes, absolutely. Now, which is why I'm saying in the peculiar facts of this case.
Now, let us see Yes, first the law, I'll come to the facts later. Then,
The
five.
contractor can utilize the services of the contract labor in any other establishment in respect of which
But
no
there's no
notification.
notification.
So if there is no prohibition, you can always employ contract labor there. And point number 6, if the contractor intends to retrench his contract labor, he can do so in conformity to the idea.
These are 5 and 6 are a matter between laborers
Between
and the contractor.
Contractor, absolutely.
Not to consent. with them.
Absolutely.
Now, huh?
Now, Manoj, what arose for
4 to 6
consideration in sale is
not
this.
rendered unemployed.
The
They are not
para-
rendered unemployed.
Yes,
Means they will continue to be the employees of the contractor.
Of the contractor.
And the vinculum juris with the contractor would continue.
Absolutely. So the contract between the principal employer and the contractor stands dissolved.
Then how you will again entry to this?
That is what happened. Now, which is why I'm saying, Manoj, the management in this case could, by virtue of sale, have asked all of us to stop reporting from the next day.
Correct.
They were well within their right to do so.
Correct.
Not only did they not do so, they continued me for periods varying between 4 to 5 years. But not only that, they engaged the vast majority of the workmen after the Section 10 notification.
With the contractor only. Yes.
Not this, yes, through the contractor, but they cannot do it through a contractor.
We have understood what you want to say.
That's all.
Yeah.
That's basically now.
Now, we are asking you, the apex court has said the effect of 10-1 notification.
Correct.
Number 1, the workforce will cease to work.
Yes, yes.
Number 2, the
Contract will
would
cease
wither
to
away.
exist.
The contract between the contractor
And the principal employer.
organization unit
Yes.
withers away.
That withers.
Number 2. Number 3, because of this
job.
withering away,
Correct.
they have protected the contract of labor with the contractor.
True, true. Correct.
That means you have nothing to do with the organization.
That's right. That's right.
Or any other.
Yes, correct. So strictly speaking, the moment a Section 10 notification is issued,
It's over.
between the principal employer and me, it should be over.
Correct.
And it is over.
If
So
that
as
is-
on that date, I cease to be a contract employee of the principal employer, in short. Because the relationship between the principal employer and me, in this case, the board and me, cease to exist on a contract basis. And there ought to have ended the matter, but which is why I'm again coming back to the facts of this case. They chose to continue, some of us. And I asked myself on what basis. It can't be on a contract basis because clause 3 specifically says going forward there cannot be contract labor.
I
And
mean to say, because the organization has violated
yes,
the power of 10-1.
I won't even say they've violated the bar under section.
There is violation.
Very well.
Blind
If
man
there, there is a, yes, Manoj, there is, why I'm saying this, please continue. I'm sorry. Manoj.
Barbara.
Yes.
This bar would address the labor force also. And you see the wording of this section.
Yes, Manoj.
So even laborers cannot violate the bar.
I'm not saying that, Manoj. What I'm trying to say is that the bar operates against the employer vis-a-vis engaging anybody on a contract basis. If you cannot engage on a contract basis, you can only engage me on a direct one-to-one, that is on a principal to principal basis. There cannot be an intermediary,
Correct. But which you have done.
which they have done. Now, when they have
Tell me the
engaged,
section.
I'm sorry, Manoj.
That situation, where is it contemplated by the section, by the parliament?
Where they continue my, yes, Manoj. Now,
Where in violation of 10-1.
yes, it's
The-
not. There is a punishment contemplated for violation, but I'm not really worried about punishment.
Imprisoned is another.
Correct, that's a different, I'm not
What
worried
is
about
the
punishment.
filter?
My aspect is this, Manoj. I asked myself from 2011-2006, in what capacity did I continue working?
I will answer that.
Yes.
We are proposing that.
No, of course, of course.
It's only an exchange.
Yes, of
views,
course.
an exchange of views. You continued there in gross violation of law.
Yes, Manoj.
They continued you with equal grossity of violation of law.
Certainly, Manoj.
If there is violation of law,
The consequence, I'll answer that. Manoj.
how could you draw honey from that?
Yes, Manoj. I'll explain how I can draw honey from that, Manoj. The consequence of the gross violation of the law would necessarily entail that there is a direct relationship of employer and employee between the main employer and me, because the moment there's a violation, Manoj, the moment they try to bring an
One judgment like that.
Manoj, there is
this issue is very frankly, probably.
You cannot make it to function. Hangilla section. Section contemplates two situations. All that contract labor
Yes, I'm sorry, madam.
section, Parliament had two
Envisioned, yes,
situations
madam.
in front of its eyes. One, the contract labor with the lock, stock and barrel would come to an
Come
end
to an
once 10(1) notification
Correct.
is issued.
Yes.
Number one. Hereafter, it is like Article 13 of our Constitution.
Yes, madam.
Laws in force,
And
laws
they-
to be made.
To be made. Correct.
That way it is.
Yes, madam.
They say, hereafter, you will not enter into any contract labor.
Yes.
The third situation which you are arguing before us is, since he continued despite issuance of 10(1).
And also employed new workforce.
Yes.
Yes.
No, don't say.
Yes, the new
It
people
is
came
new.
in.
Through the contractor only.
Through contractors, through contractors.
Therefore, where is that contemplated in this?
It's not, Manoj.
act?
It is not. In all fairness, Manoj, it is, I searched for judgments, I could not, the section definitely doesn't contemplate that. The section does not.
Ruling on this act, we are only telling that head-ons principle.
Yes, Manoj, the mischief sought to be, yes.
This section says, X, Y.
Yes,
X hitherto,
correct.
Y hereafter.
And if you violate that, there's a penal provision.
Penal provision, you get him imprisoned. You can take Dan to Gaul, is another
No,
thing.
I may not
But
interested.
how that is going to give a right in your favor?
No, I'll explain once again, Manoj, how that gives the right in. I'll just take one step back, Manoj. As your lordship saw, the contract labor ceases to exist on the date of issuance of the notification, which is why I'm saying again, Manoj, the management would have been well within their rights to ask me to pack my bags and go home, because that would be in accordance with the object of section 10. They chose to, in your lordship's words, violate the provision. I would put it in a more nuanced manner. They chose to employ me thereafter.
In
Now,
violation of law.
In violation of law, yes, my lords. So, but then once they choose to once they choose to employ me, whether it be in violation of law or otherwise, and in this case, it's in violation of law, I would respectfully submit, and this is what the proposition your lordships may have to hold for the first time, that
No judgment on this?
no, but that I asked myself, which is why that question really boils down to this: in what capacity did I continue working? Point number two: in what capacity was I appointed after 2/11/2006? If it is in violation of the section 10 notification, it cannot be that the only consequence is the penal provision under section 25 or whichever provision. The consequence, as far as the workman and the relationship between the employer and me, is that with your eyes wide open, you asked me to work. You in fact appointed me after 2/11/2006. So you knew very well you could not have appointed me on a contract basis, but yet you choose to appoint me through a contractor. Therefore, you were aware that there cannot be an intermediary. Therefore, you were aware that I have a principal to principal relationship with you. I am an employee, you're the employee.
No, the law would have said that.
The law doesn't say, in all fairness, the law doesn't say,
I would say Parliament did not understand this. Parliament does, these statutes are made.
Yes, ma'am. No, exhaustive, of course.
This is view.
Yes.
This is law and public opinion in 18th century England.
The Parliament is supposed to be aware of everything.
Ah.
Yes. No, but Manoj, the consequences of the law, I'm not sure it has to encapsulate in every manner. Now, there is a penal provision. I ask myself, if you continue in an unfair manner the employment of vast number of employees, is the only consequence, like as your lordship said, throw somebody in jail? I would respectfully disagree with that, Manoj. There has to be some consequence to the employee also.
He should also be sent to jail.
Not sent to jail. He has to be continued, is what my consequence in a good way. I mean, I don't use the word
that.
consequence in a bad.
We judges are only, we sympathizing with the workmen is one thing.
Yes, of course.
But we will have enormous consequences because
Correct.
the judgment which we are going to render.
No,
this
it'll
way or
have
that,
wide ramifications.
because of Kusumin God, it will have repercussions all over the country.
Absolutely.
And you are saying that there is not even one single judgment.
No,
Which
as far
says-
as, yes, Manoj. The sale judgment at the point of whether I'm entitled for automatic absorption. It says no.
Even
I can't assert it.
I'm sorry, Madam. The point which we are debating now.
SAIL did not consider.
That
SAIL
was
SAIL
not
did not
considered
consider.
at all.
There are aspects regarding the effect of non-registration under section 7 and 12
There
that
we
is
can
considered.
understand. That's
So-
only, no, that two objects which you have read.
Yes,
One is regulating the contract labor.
correct,
Another is putting an embargo
Prohibition.
on contract labor.
correct.
So when it comes to regulating, we can understand.
Yes, ma'am.
But where there is a prohibition in so many words,
Yes.
the language of section 10(1),
Correct.
it leaves no interpretation, scope for interpretation at all.
Can I just
You
put it in-
shall not.
Yes, absolutely. There are no two ways about it. Now, can I put it in a different
Then
manner?
we'll go to one step further. Kindly read section 23
Yes, ma'am.
of Contract Act.
Contract Act. It's a void, yes, ma'am.
Not only that, just see. It's not that simple wide. The chitty on contracts, Cheshire, Fifoot and Firmston.
Yes, ma'am.
And law of contract, English law of contract has discussed this aspect.
Section 23, madam. So what the consideration or object of an agreement is lawful unless it is forbidden by law or is of such.
Or object.
Yes, ma'am. So the consideration or object of an agreement is lawful unless it is forbidden by law or is of such. Yes.
It fits into first one.
Yes, ma'am.
First one.
Correct. It's forbidden by law.
At least it will fit into the point 2.
Is of such a nature that if permitted would defeat the provisions of any law.
Then one
Yes.
would be defeated. If it is not one.
Yes, ma'am. It's correct. And then I think, yes,
Anyway,
ma'am.
it fits into one. We are in agreement with that unless Dan himself says, no, we do not fit into one also.
Yes, ma'am.
If that is so,
Yes, ma'am.
asking us to absorb your services.
Yes.
Would it not be a case of placing premium on illegality?
A premium on illegality or committed by whom? Not
By
by
you
whom?
also. Why did you go there?
No, that's there. For me, I was working there. I was subsequently appointed. Now, yes,
Law does not exclude you.
yes, ma'am.
Like offense of bigamy. The woman was excluded.
No, but I understand. Ma'am. Now, can I just answer that question? Now, as far as the
Let us see the penal
alleged
section. Penal section.
under the act, well, I'll just come back.
23, my lord, section 23.
Contravention of provisions regarding employment of contract labor, section 23.
How all these years this question remained untouched by any of the court?
Most of the issues arose vis-a-vis the effect of non-registration to section 7 and 12, which is what the Gujarat High Court had initially said, that the moment there is non-registration to section 7 and 12, we were going to assume or presume shamness of the contract.
See the word. No?
Yes, ma'am.
It chooses the word which Macaulay chose in IPC.
Yes.
Whoever.
Correct. True.
It not say if the establishment does it, if the contractor does this. It
Yes,
does
ma'am.
not say that. Whoever.
I think that might be, I mean, with great respect for that, I don't think the act contemplated a penal provision to apply to an employee, although it uses the words whoever.
Otherwise,
Now-
any how this section is interpreted.
No,
How
because
this word
I'll
is
explain this.
interpreted.
No, I'll explain this. Now, when a lordship says whoever, the prohibition is under section 10 on the establishment. Now, if the establishment violates section 10, so whoever will be qua the establishment. This is how I would, I mean, of course, this is the first time even I'm thinking of this, so I'm answering as I'm thinking aloud, to be honest.
There are judgments.
Yes, ma'am.
There are judgments of Privy Council and of Supreme Court, Honorable Supreme Court, which have interpreted the word whoever.
Interpret the words.
Whoever.
Yes, ma'am. Whoever. Yes.
Notice, Surendra Malik on words and phrases. Supreme Court on words and phrases. That's
Not to interject with my learned friend, my lord, but I was only saying on a lighter vein, if your lordship looks at section 65 of the Contract Act,
65.
because my learned friend is employing section 23 of the Contract Act,
the consequence of voidness is in section 65. That is quantum merit. Yeah, Quantum where merit. yes, Lord, basically restoration. It is recompensing the person. That's what. This is called the doctrine of
Quantum merit, correct. For the work that you have done, you have to get adequately compensated.
Yes, Lord, in a way that is also quantum merit, but quantum merit also can arise in a situation where there is there's some kind of a contractual relationship, but which is not in writing, and some performance has been done, and therefore there has to be a compensation for that performance. Very good. I have seen. Yes, Mr. Vikram, kindly say that.
Whoever, that is the word whoever occurring in the opening part of section 2 of the penal code refers to a person other than the offender and has no application to the person who is alleged to have committed the principle. Malaz is referring to that.
But there are judgments, sir. But
Yes,
this book is not, completely sariyag baradang illa. There are at least 2 judgments of Privy Council.
I'll just check that.
Half a judgments of.
No, I'll also do my research on that.
They have said, they have followed Fowler's English dictionary and usage. They say, whoever is a word of larger import.
Wide purport.
Wide import. Therefore, there is nothing indicative in that section which excludes the culpability of
I would put it
employees.
this way, Malaz, keeping in mind the intention of the act, which is to protect the contract labor itself. The object of the act was to abolish and regulate contract labor, and for whose benefit? For the employees. It wasn't to benefit the establishment. So therefore, Malaz, no, I would put it this way, Malaz. It's a social welfare legislation. Malaz. The only object of abolishing or regulating is to ensure that there is no unfair practices that are meted out to the employees. So therefore, it is to protect the employees and not the management. For example, Malaz, Industrial Disputes Act. Of course, it was to protect both. Factories Act, Malaz, is to protect.
There are provisions in the ID Act.
Yes, Malaz.
Provide for the punishment of workmen also.
Of course, Malaz, of course. That's why I said that. ID Act covers both. But this, Malaz, I would respectfully submit, Contract Labor Regulation Act was to protect the labor force itself and to ensure that there are no excesses against them. Therefore, by either abolishing or by regulating. So therefore, keeping the larger object of the act in mind, I'm not, with great respect, I'm not in complete agreement with the fact that whoever may include the employee, but anyway, that may not arise really for consideration here, Malaz.
No,
I'm on the point of, I ask myself, Malaz, is the only consequence of a section 10 notification violation, the penal provision under section 23? I would respectfully say no, Malaz, because given the conduct of the employer in continuing me on this ad hoc basis for not just 1 or 2 months, but for a considerable period of time, and continuing to employ more people, it must necessarily entail other consequences. And it need not be automatic absorption, because SAIL says there is no question of absorption. But the moment my whole endeavor here is to establish a relationship of employer and employee between me and the board. My submission is there cannot be an intermediary after section 10. If there cannot be an intermediary after section 10, there are only 2 people left really,
No,
the employer and me.
No, Mr. Vikram. Section does not say.
Yes,
Wherever contract labor is employed, once notification, 10(1) notification is issued, the contractor withers away, the contract withers away,
yes,
and the employees, the laborers would become.
It doesn't say so, but it does say the first 2, Malaz. The first 2, that's what SAIL says. The contract withers away.
Correct.
As a result of the contract withering away, the contractor also has to wither away.
No, simply we would have understood.
Yes, Malaz. No,
further says
vis-a-vis the.
They will continue to be the
Yes,
employees.
I
of
will
the
continue.
contractor.
Absolutely, Malaz. I have no qualms about that. But here, Malaz, what happens is I continue to be working for not just the contractor. If the contractor, Malaz, could have easily taken his entire workforce, including me, and put me in another establishment where there is no section 10 prohibition. That is what is contemplated under SAIL.
No, your argument runs counter to
Yes,
what the Supreme Court has said. Honorable Supreme Court has said.
Yes, Malaz.
Kindly see 4, 5, and 6.
Yes, Malaz. Which is why what I'm saying.
Let us read
Yes,
again.
I'll read it.
Let us
Certainly.
understand.
Should I read from 1 again, Malaz, or
1 to 3. 1 to 3 have to be read in the light of 4, 5, 6.
Yes, Manas, absolutely.
You cannot breach any one of them to
No,
suit particular
no
employee.
question of that, Manas.
We should be kind to the laborers is one thing.
No, no,
But we have
I'm not,
to adhere to the law also.
no, I'm not for a moment am I trying to reach out with any,
Labor, your
But it
entity.
is a relation continues here.
Ah.
So again, a violation of these things, if it is continued, consequences of the revival of the relations.
We will just analyze.
yes, Manas.
Because it's a very serious
No,
issue.
it is a serious issue.
The life of many workmen is involved. We
True,
understand.
true, true.
ಅಷ್ಟು ಜನರ ಜೀವನದ ಪ್ರಶ್ನೆ ಇರ್ತದೆ. ನಾವು ಹಂಗೆ ಏನೋ ಒಂದು ಬರ್ದು ಹಾಕಕ್ ಬರಲ್ಲ.
Yes, Manas.
ಆಯ್ತಾ? ಮತ್ತದು ಇಲ್ಲಿಗೆ ನಿಲ್ತದೆ ಅಂತಾನೂ ಅಲ್ಲ either way. We know that also. Therefore, kindly see that.
Yes, Manas.
Very simple. Contract labor
Yes, my lord.
ceases to function.
Correct. The contract labor in that establishment ceases to function. Yes. The note,
The contract principal employer
correct.
will go away.
Yes, Manas. The contractor will go away.
Go away.
Yes, my lord.
3.
Oh, sorry, sorry, point number
Thereafter, you
2.
will not do A and B.
I'm sorry, my lord.
See, number 1, 2,
Yes,
past.
correct.
3,
Future.
future.
You cannot engage contract
I
employment.
understood
Yes,
this.
correct.
Come to 4, 5,
Yes,
6
ma'am.
now.
4 is contract labor is not rendered unemployed.
Ah.
So there is, what that contempt, I'll just explain, madam. What that
Let us read
contempt.
fully.
Yes, madam. The contract labor is not rendered unemployed as is generally assumed, but continues.
Continues in the employment
And
of
I'll
the
explain that. Now,
contractor.
why the Honorable Supreme Court thought it fit to clarify this is in light of para 6. The moment a section 10 notification is issued, in order to protect the employee, the contract employee, Supreme Court said 2 things. You continue in the employment of the contractor. And if he wants to retrench you, he can only do it via the provision of the ID Act. Otherwise, there could be unscrupulous contractors who said, listen, there's a section 10 notification, please pack your bags and go home. In fact, this is beneficial to the employees to the extent of protecting them from their retrenchment from the contractor.
Any judgment to that effect?
This is how I would read this, my lords. These clauses of sale. But I'll do some more research. If
Kindly come
it's,
to 200 of the ID Act, where retrenchment is defined.
yes. ಇಲ್ಲ.
Parliament is very, very clear in its vision.
No, just to further, maybe I have also not put myself, I'll take my lords to some more judgments. Now, why I come back to the Parliament could not have possibly envisaged all the consequences of a section 10 notification. Possibly the answer lies also in some judgments vis-a-vis section 7 and 12. Now, taking a departure from this, my lords, let us assume there was no prohibition. The principal employer was liable to be registered under section 7. The contractor was liable to be registered under section 12. Now, there is a judgment of the Honorable Supreme Court, in HSEB's case, which says that even though, not in express words, but to paraphrase it, even though there is no consequence provided in this statute, the effect of non-registration under section 7 and 12 would lead to an assumption of shamness. Now, I'm drawing a parallel just to answer your Lordship's question as to how the legislature could not sometimes have contemplated all consequences. There is no consequence provided for section 7 and 12 violation other than a similar penal provision. But the Supreme Court judgment says that if you don't register under section 7 or 12, I'm going to assume that it's a sham contract because your contractor is not registered, you are not registered. So I will presume shamness.
The shamness issue.
Only to answer that question because
we have got the point. With my limited exposure to law of contract, limited exposure.
Yes.
I have not
No,
much read on law of contract. I tell you, I confess that, except Anson's law of contract, Chitti on contract,
that covers,
Cheshire Firmstone.
I don't think much is left after that.
On the elementary things, on elementary things. Of that, question of shamness arises only if the contract was not sham and is not prohibited by law.
Correct.
There cannot be
Yes.
idea of shamness of a contract
Yes,
which would be contrary to.
No, there are no two ways about it. No, again, just to explain why I gave that example is this. Your lordships rightly pointed out that the legislature in its wisdom will provide for all the consequences. And if the legislation does not contemplate it, the courts cannot read the consequence into the legislation. Now, to answer your lordship's question there, I was drawing a parallel to judgments of the Honorable Supreme Court, which say that one of the consequences of non-registration